Seven. Page by entry, page number 1, item number 1 to 8. Page number 2, item number 9 to 16. Page number 3, item number 17 to 28.
58. I'm appearing for the petition. On the other side, the interim order will be expressed with take the date and next week I will submit to my
Item number?
28.
Item number 28, you are making mention at 10:30 seeking extension. Is it permissible? Wait for your turn. Yes.
Page number 4, item number 29 to 45. Page number 5, item number 46 to 52.
I think it is a 2019 9 months. So already we have given letter to the registrar.
Yes, hand over to the court officer.
Okay. Both cases are spread appropriate cases. Last cases had made it as part of the for vacation. That's why some say unless last week the punishment will not take into account. Chartered accountants are professional. Tuesday, the last. Holidays are there.
On 14th. Yes.
2021 petition.
Have you given a letter to the registrar? Where is the copy? Hand over the copy to the court officer. Yes.
There is a direct suppose that the
Yes.
tomorrow.
Yes, tomorrow.
That's the 3012 of 23 ballots was supposed to be listed yesterday. Kindly permit me to move a lunch motion.
Yes.
Freedom fighters pension matter was 3 days of
Yes. Verify list on 15th.
2016 matter, Milan.
Yes.
146/22 of 2016, Milan. The medical university not issue the my original certificates, Milan. Kindly have it day after tomorrow or Monday, Milan.
Yes.
Monday.
Verify list on 9.
146/22 of 2016, Milan. Already the slip in my colleague, Milan.
No. 146, 22 of 16.
Yes.
April.
List on 9th. I said
Achha.
9. Yes.
Much obliged.
As potential of entry mode.
Yes. 2:30. It has been filed today. 2:30.
Time today, but not listed.
2:30 today.
Tomorrow.
Yes, tomorrow.
Page number 1, item number 1, P. Panduranga Reddy, GP for Higher Education.
Yes.
But the issue is initially was official for 2 sections in 3 years course and 1 section in 5 years. Thereafter, for the during the academic 17, 18 minutes, it was higher education and 2 additional sections. So these 4 sections in PS and 1 section in 5 years. But according to the 18 onwards, not post. But 4 additional sections PS code, 1 section in 5 years. That is being concluded today. This present academic year, the university now issues the postings dated 26/10/2023. I think under reducing 1 section out of 4 minutes, 3 sections were granted application for 3 years code and 1 section 5 years. So in fact, they have not any notice, showcase notice before releasing the intake. But while the inspection was going on, after going through the inspection report, I myself submitted complaints report at page 35, 36. 2 complaints reports were submitted. One level 8 and another is at 29A. All I am seeking without considering that complaints report, the university has issued the postings. Therefore, I am only requesting to come direction to the university, consult the complaints report and issue fresh postings.
Is who appears for the university? Yes.
The order shows 50. 26 of the
Yes.
for the possibility that is the college to fulfill the conditions for deficiency bank. 26 and 23 order.
In this order, Milord, the intake is only for 3 sections. Let's do it. That some time doesn't take.
This is what my instead of 240, they have granted very. The stage level so kindly appreciate. From 2018-19, I was never told that I can understand the faculty, books, computers, all those things because but in fact, so far the building is concerned, university never established this is page number 15, serial number 8. I have found different deficiencies 5 class. First time this could not have been the case. None of the authorities have found deficiencies of books. Anyway, Milord, I am not going to. I am only.
Consider the compliance report. Oh, unilaterally from 240, you reduced it to 180. Unilaterally. Have you put the college on notice?
No,
Objection seems to be filed in the month of August 26.
Yes.
Subsequent to that, only the present order.
Yes, you consider the compliance report and take a decision. Yes, right?
I know that whether that action is considered.
Yes, I'll post it on text.
Yes.
Yes, 9th, in motion list on 9th. Yes,
In the prayer, instead of 29-8, it's like plus 26.
yes, corrected.
Item number 2, B. Kirti, G. Praveen Kumar, Deputy Solicitor General of India, GP for Home.
10th. Yes,
This will be disposed of the directing the respondent number 2 to dispose of the representation. Representation was made by the petitioner against the respondent number 4 because non-available warrants were pending the law. So by including of the respondent number 4 last 4.
Sorry.
yes.
The presentation was made in the year 2022, 14/6/2022. month. I can say respondent number 4 passport ballot because now 4 non-available warrants are pending. It may be disposed of directing the respondent number 2 to consider my representation.
Yes, who appears on behalf of the passport authority, respondent number. Sampada. Her name is not printed in the list? Yes, friend.
Item number 3, Mohsin Sharif, G. Praveen Kumar, Deputy Solicitor General of India.
He said 9. Yes,
And I am appointed to the Program Council for State Bank of India for the conditional account of projects at the time of the bank finance demanding for special commission from my side. I am rejected for that, and the case has been registered in duplicate grants. So for that, grants I removed the micro from without participating service, very reason from bank. So at the time, and also the transfer business of bank. So at the time, the order to do the reactivate my code and pay the bank from my transfers.
yes. You take out notice to the respondents, friend.
Item number 4, P. Venkateshwarlu, G. Praveen Kumar, Deputy Solicitor General of India, GP for Home.
Please the passport for the correspondent. Correspondent issued a letter 19/7/2023 stating that they can consider his application if we submitted agreement of the case or after permission the same 11. the petition was arrived as the accused number 1 in 498 case before the 15th Metropolitan Magistrate Court. Prior to registration of the case, the petitioner's wife took away the passport and all his belongings. So that he also lodged a complaint before the police SP Nagar, registered under section 380 and other sections. Now the passport is lying with the petitioner's wife here. So that the petitioner approached before the land court, stating that the application was filed under section 6 clause 2 of Passports Act, and the land court dismissed the application. So that the petitioner was approached the honorable court by way of writ of mandamus. The third respondent is not issuing the real passport. Any direction is required for issuance of the new passport.
Yes, who appears with the respondent? Yes.
What with you? You must be just surrender that passport. It should be as the lost certificate. Because what in this make instruction.
Yes, madam.
Charge sheet also filed by the PS
Yes, notice before motion, list on 10th in motion list.
Number 5, by Manjulata G. Praveen Kumar, Deputy Solicitor General of India.
Yes, who appears for the petition? This person? Who appears for the counsel for the petitioner?
By Manjulata G. Praveen Kumar, Deputy Solicitor General of India.
Right.
Freshman.
Trading security services. Registered between the security guards and the company. And made a contract with the companies. My mode of operation is only to take 7% margin of the employee salaries. That my property, instead of my property, the respondent number 2 attached to my wife's property. It was not there in any of the Act section 8 clearly stated that organizational property. My organization, some job is there for 2.64 lakhs I have received from the company. The company was went into the liquidation before IPC, which as per IPC code, it went into liquidation. Even though I paid salaries, I honored the salaries of the employees. And attachment of property of the organization. I am a proprietary concern, my lord. And nowhere in the act it was stated that the attachment of my family members are. Page number 39.
Yes.
Order of attachment of removable property. Removable property of 93 lakhs 12,535 for the period of 2017-18. And it's 64 lakhs 66,834 the next page of order of attachment for the same property. The property is in the name of my wife and it is encumbered. It is encumbered with Punjab National Bank. And the procedure adopted by computing the calculation of the PF method has to be remand back and reassessed. The property documents. The principal company. The principal company where I got contracted. The company went into liquidation for the NCL. So if they are due for 90 lakhs and I have to pay the same amount and even the debitors amount, my organization as per the balance sheet speaks method of accounting, my debitors is on my asset.
Yes.
So instead of attaching my assets, even property, furniture, removable or movable, they attach my wife's property man. If my wife triggers me by issuing any divorce notice, by taking this, it's just very difficult for me.
Yes.
Even I communicated the same in page number 37. And the liquidation order was there in page number. My demand was accepted by the liquidator in page number 49 by the principal company, where I provided services for security guards.
Yes. What do you say?
Section 8 very clearly stated, madam, attachment of organization property or criminal action against the proprietor, not attachment of my family properties.
What do you say on that aspect?
Establishment. Several employees were made complaints against the establishment saying that they have deducted the amounts from these companies. However, those amounts were not transferred, remitted to the EPA. But the complaints given by the employees not that is reflecting at page number 18. Complaints namely got from the bottom of the page, both the employees complaint. So both Rajan Panda, Purendra Vamshi, Naveen, and the based on complaints, the EPF organization conducted inquiry and passed 7-year orders for determination of amounts at page number 70. This order was on this order passed on 25/7/2020, more than a year back. They have contested the matters before the 7A authority. That is, their names also reflecting Shankar Baburao, managing director. And their duty to aggrieved by this order, as per statute, it is providing alternative remedy of approaching the EPF80 under EPF 7A of the Act. I may be permitted to read the 7I of the Act. Appeals to tribunal. A person aggrieved by the notification issued by the central government or an order passed by the central government, any authority under provision subsection 3 or subsection 4 or section 1 or section 3 or subsection 1 of section 7A. This is passed under 7A. An appeal is available to the petitioner to approach the EPF80, and EPF80, as per rule 7 of the EPF80 appellate tribunal rules, they have to deposit 75%. Within 60 days limitation is there for approaching the EPF80. Now, without challenging this order, and also another order also passed under 7A at page number 28.
Yes.
Without challenging the orders passed under 7A before the appropriate authority 7A, after they testified after 1 year, now they are approaching this honorable court. Moreover, the ultimate sufferers are poor employees. They have not made as party respondents based on their complaint initiation of 7A proceeding. Further, having deducted the amount from the employees and not remitted to EPF organization is amount to criminal breach of trust and liable to be prosecuted under 405, 6 and 7 of IPC.
Yes.
One of these matters is very checking the procedure adopted by the authority. Procedure adopted by the authority is totally wrong. Actually, the company has to provide the salary, the employer pays to me. I have to pay salaries to the security guards. From past 3 years, I have not received any of the amount from the contractor. So where I have to pay, even though I am ordering the salaries. From past 3 years, even COVID period and before the difficulty, the outstanding due was clearly mentioned in case number 54 million.
Even in the present petition, he has not challenged the order under 7A. There is no challenge to the order under 7A.
As on today holds good. Without challenging determination order, they
Yes.
cannot challenge
Subsequent
proceedings.
consequential.
Proceedings cannot be challenged unless until 7A orders are.
2008 hours, by concluding 7A, 2018 hours, the company is under liquidation.
Your remedy is to challenge the order under 7A. I'll direct you to prefer an appeal under 7I against the order under 7A within a period of 2 months, 2 weeks. And in the meantime, they will not take any coercive steps. That is the only thing.
Attachment of property.
You have to first challenge the 7A order. You have not challenged the 7A order. The order is dated.
That's what
The order is dated 25th July 2022.
my humble submission is that whatever the salaries they computed on the total salaries one company was defaulted.
Even in the present petition, you have not challenged the proceedings dated 25th July 22. You're only challenging the consequential proceedings. Yes. How can it be?
Already passed.
Yes. My own order is there. Pass on a copy to post on 9th. Yes. Look into that. Yes. Yes. I did not dismiss. I simply ordered notice and
Granting liberty or dismiss, otherwise.
Normal, I come with the accurate order passed by the NCLT. Kindly permit me.
yes,
Posted.
14th. No interim orders. Post on 14th, notice before admission. Yes,
Item number 7, L. Ram Singh, G. Praveen Kumar, Deputy Solicitor General of
For
India.
your lordship, the level of the passport, the very same name, your lordship, is a page number 19, earlier passport is also there,
yes,
which has been issued in the name of Hajira alias Kapika Begum. Now, Malada accept for the renewal. They are refusing to issue the passport in the very same name, your lordship. They want to remove the alias name, which is affecting to my children's education benefits, your lordship. And even Malad, one of the son is out of the country, Malad. If they will not issue in this name, Malad, there is a difficulty to visit the son and the daughter, Malad. Malad, my application is also pending, Malad, before there is also page number 18. Applied, Malad. Only when the, there is same name of the Hajira Kapika alias.
yes. What do you say?
Page 40, they want to omit the area. Page 18, 19, you should.
They are refusing to issue the
Alias.
passport in the alias name. In the
Their passport
2011,
is the alias Rafikia Beg. Get instructions here also.
2011,
Yes, right.
Item number 8, B. Arjun Rao, G. Praveen Kumar, Deputy Solicitor General of India.
He's standing before the passport. But after he's certified the order.
Yes,
Page 42.
yes, same order.
Page 29 is the legal form. Page 29.
Similar.
Yes.
Line on this, that order was passed. They reported there.
The usual order.
Yes, sir.
Yes, sir. Customary.
Your lordship's item number 9 may be permitted to withdraw, my lord. Mr. C. Raghu name is printed. I am Uma Devi, is the present standing counsel for Genco and Transco.
Yes,
And for the respond number 2, Millard.
yes,
I may be permitted to withdraw, my lords.
yes, right. Ms. Sudha for the petitioner.
No, Millard, Uma Devi is the for petitioner. Previously, C. Raghu was there, but now Uma Devi
Uma Devi for the petition. Yes,
published, my lord.
Item number 10, P. Falguna Rao, B. Mayur Reddy, K. Srinivas Rao.
For dismissal.
cause of action survives in this?
Yes.
You appear for the respondent?
Counter in.
Yes, license period expired when? Page 24 of your?
Page 25. 2 years.
19th March or 19th May?
We have paid all the amounts which we have deducted from the petitioner, the higher charges.
Yes.
Paying the higher charges of rupees 16,000 for the first fortnight of the for invoicing financial on the charges. But after the kilometers, right, pay all the. There was a. That's not it.
You're referring to para 11 of the counter?
Yes.
Yes, ready. Write your name on a slip. Yes.
Item number 11, P. Ravikant, K. R. Koteshwar Rao, GP for revenue by
Yes. What is it? Yes. What do you want?
The expedition was by questioning the action of the first responding area of we have made an application to issue a making the construction. They stated that we have to get the NOC from the airport authority and the first respondent has rejected our application for which the construction only the ground floor.
Yes.
Questioning that the application was and now that the been shifted here, notified earlier also there was an intent action in the similar application page 9 of my website pages. They state that the controlling raise any objection here with regard to the construction making of the construction ground blessing right now the that's from that place. Page 10 of my material papers.
Page
10 years of material papers. Section 9 to view of the aircraft Act imposes restrictions regarding height of the buildings which are coming in the way of landing and taking off aircraft from the way of the airport and the views of height of the aircraft. Section 2 that cantonment is permitted to use for enforcing from the airport. The Law Council for the petitioners submits so far as the petitioners are concerned, they are only intended to undertake the construction of single floor, and therefore the construction is not affected by the restrictions imposed in 90 of the Aircraft Act. And now we are has been shifted, there was only a construction of only 2 floors. There is a written in the same petition,
have you given her a copy?
Ravi,
Now the airport itself had been shifted. You appear further? You're representing Mr. Koteshwara? Password? Yes.
Item number 12, B. Venkat Mayur and Krishna Rao, Arvind Kumar,
I beg to represent Venkat Mayur, my lord. The matter gets infectious, my lord. No orders are being required.
Does not support the execution. Bringing the said submission. The interim order is vacated. Yes, yes.
Item number 13, A. Sanjeev Kumar, KVN Reddy.
Right. October 2020. 6th November 2022. And again, today it is on 7th November 2022. Case is disturbed. The learned counsel appearing on the response. Petitioner approached the court seeking prayer as a witness. This counsel appearing on behalf of the respondent to permit for the court the cause of action in the present petition. Does not stand for adjudication in accept submission of record. The petition is dismissed as input. The interim was granted by this court. Granted by this court on 28 April 2014. Stand vacated. Yes.
Item number 14 and 15, Chandrasekhar Reddy G, ST Ramna.
6 to 13 paper
is the maximum of 10,000. 2021 now is appearing and asking for it. Last time also yes, same representation, last take from the section, whatever.
even in the section, even in the office, the papers are not available.
Last year also.
On behalf of respondent 6 to 13.
We give up. We are the contesting respondents. They are the university. They already sold the property. Top of third one. Myself not.
But claim is being start against us.
As a pro forma party, they were made.
We are taking relief against every respondent. None of the unofficial respondents have a semblance of a right interest or in the title of the property.
Even then we present and we should have right.
Today itself, I'll ask my friend to give the papers. On 2 days, he'll give all the papers.
It's a huge compilation.
So huge compilation. You will talk at 2 days.
Yes. Items 14 and 15. Items 14 and 15. The council. So for the petitioner is present. The honored counsel appearing on behalf of 6 to 13. 13.
Very well.
That is on 30th November.
Very well. So that is.
Till 19.
Last minute.
Respondent 6 to 12.
6 to 13.
6 to 13.
Last year, no further even 15 was.
No further adjournment.
Last time also same representation was made.
Yes.
Very well.
Item number 16, in this law form, Sharat Sanghi. It's a arbitration application.
The short point is involved. It is the share purchase agreement. Companies have children. The matter must they must take the matter to the company's court arbitration. India Attorney case is covering this one. India Attorney is completely covering this point of 86. Intra-company disputes. This is the dispute between two companies with respect to the allotment of shares. It's the same, the shares are not allotted. The names have not been created. It was in section 59. The company is.
Against the collaboration, abruptly stating that thinking about harmony, therefore it should be better be in business relationships right here and continue to be good friends. That's the way they terminated the contract. Which is why we have. Also, can you take it after tomorrow? We'll ask her.
Yes, day after tomorrow. The council for the petitioner request the matter to be taken up on 9th at the request of the council. The petitioner list on the council for the respondent is present and continues the remedy available to the petitioner is under section 59 to compare with any this act and not advocate.
Page number 3, item number 17, Samar Sandeep Reddy, Additional Advocate General.
Contempt case, once we passed the order in April, it has not been implemented. So contender has already filed a counter.
Letter has been opened.
They have to appoint a regular GMB. The post was created in March. 6 months, my lord. For a minute, your lordship, I can see your page 19. It starts.
Yes.
The relevant page for 21 is this court in bold.
Yes.
This court appoints the prime minister the appointment of third respondent as per GR for so and so dated so and so. It is contrary to Rule 10 of the Telangana State and Subordinate Service Law. And also is contrary to the principle decided by the division bench of this court in order dated so and so. Therefore, there shall be interim suspension of the operation of GR number 603 as prayed for by the petitioner, and respondents number 1 and 2 shall fill up the set post strictly in accordance with the law. The post that we are talking is about the Director of Medical Education. This is a writ of quo warranto challenging the illegal continuation and appointment of third respondent as Director of Medical Education, which he was appointed as an in-charge appointment. And I have shown you a lot relying on the rules and the division bench order passed by this honorable court, which categorically say that there cannot be such in-charge arrangements for almost 5 years. The in-charge arrangement was given in 2017. We are now in 23. He is still continuing as an in-charge Director of Medical Education. And your lordship may kindly see the counter filed by the first contender also. It is categorically admitted that they have to appoint. And that they are appointing, they are taking this at snail space. They are for a minute. You lot can you see the counter fight by first country.
We have filed against their counter in this petition. See, like the Melody was to take a petition counter petition.
For a minute, you know, can you see the counter fight by first country. This is filed on July 23.
Yes.
Page 3, your lordship can see para 7. Para 7, your lordship can see. Yes. It is further submitted that now the government of Telangana issued orders by GORT number 31. This is dated 16 March 2023, creating the post of Director of Medical Education, and the same was communicated for taking necessary action by government order dated so and so. That is 27 March 2023.
Further, it is also submitted that necessary steps are being taken by the government for filling up the post of Director of Medical Education and necessary modification of rules if any need to be issued. After completion of the said exercise, the post of Director of Medical Education will be filled up and process of filling up of the same is in progress. They admit in March itself that they have to do it, and your lordship passed an order in April. Now it's been 6 months from your lordship's order, 7 months from their admission that they have to fill it up. And my lord, in the meanwhile, the second respondent is continuing as Director of Medical Education in the gross violation of your lordship's order. Because your lordship's order merely not state the appointment, your lordship's also directed that a regular Director of Medical Education has to be appointed in pursuant as per law and rules.
Yes.
And therefore, I respect that necessary steps may be needed.
Again, 4/2020
I have red petition. This only is.
This matter. The kid will not come.
No, it will not come because that is in the red petition.
Yes, sir.
The wicket is not my subject now. Yes.
Insofar as contempt.
Directed them to comply. Yes.
Item number 18, party in person, GP for social welfare, B. Varaprasad, MB Durga Prasad, GP for school education.
Representing. Which respondent number 6? Yes, right. Yes. Let's get now. Yes.
Item number 19, Amar Sanjeev Reddy, Advocate General, A. Prabhakar Rao, GP for General Administration.
The writ of warrant for challenging the illegal continuation of the court respondent as the Vice Chancellor of TSHC University of Health. Even after the expiry of his term, as per the Act and the TSHC is constituted. Your Lordship, kindly see the Act at page number, starts at page number 16, page number 23 is the resolution. Earlier, court respondent, I was directed to issue person notice, have already issued person notice in service. For a minute, watch me kindly see page 23, section 11. My lord.
Yes.
The governor of Telangana shall be the chancellor of the university. The chancellor shall by virtue of his office be the head of the university. Then your lordship kindly see 12, section 12 under it. The vice chancellor shall be appointed by the chancellor from out of a panel of 3 names of distinguished educationalists in the field of medicine in alphabetical order suggested by the committee consisting of so and so. Why I am demonstrating your lordships is that the responsibility to now fill up the post of vice chancellor falls on the chancellor, that is the governor, who is second respondent here. And you now see the term of the vice chancellor at page number 25. Page 25. Second schedule, Vice Chancellor, Section 1, subsection B, ma'am. Subject to the provisions of Clause C, the Vice Chancellor shall hold office for a term of 3 years from the date of his appointment, and he shall be eligible for reappointment to that office for another term of 3 years only. Then your lordship will kindly see the last condition. Provided further that the vice chancellor shall, however, continue to hold office after the expiry of his term of appointment for a period not exceeding 6 months, or until his successor is appointed and enters upon his office, whichever is earlier. Therefore, my lords, his term is 3 years initially, extendable by another 3 years, and then another 6 months is granted to appoint his successor. Now, your lordship may kindly see when he has been appointed.
Yes.
Your lordship may kindly see page number 28. He was given an additional charge, my lord. I am not relying on this. For a minute, your lordship may kindly see page 28. The fourth respondent was given additional charge. Page 28.
Yes.
Fourth respondent is your lordship may kindly see in excess of powers conferred by section 12, Dr. NDR. Earlier it was called Dr. NDR. Subsequently, it has been adapted. Now it is Narayan. Adopted by the government of Telangana by reference first section, government hereby appoints Dr. B. Karnakar Reddy, that is the fourth respondent here. So and so as Vice Chancellor of HIGHCOURT University of Health Sciences on full additional charge till the regular appointment is made. Overleaf, your lordships will find the regular appointment. This is dated 31 December 2016. The in exercise of powers conferred under section 48 of KNR University of the Chancellor of HIGHCOURT University of Health hereby appoint Dr. B. Karnakar Reddy, again fourth respondent, as Vice Chancellor of KNR University for a period of 3 years with effect from the date of his assumption of office. So his term starts here, my lords, at from 31/12/2016. And my respectful submission is, as per the act I've just demonstrated, 3 years plus 3 years that expires on 31st December 2022. Then he has another 6 months. That expired on 31st June 30th, 2023. He is still continuing as the Vice Chancellor without any power. Overleaf, your lordships will file another. My lord, he has to be again given another term of 3 years, but he has not been given. Your lordship will find at page 30 overleaf. This is dated 30 June 2020. In exercise of the powers conferred so and so. Dr. B. Karnakar Reddy as Vice Chancellor of Health University temporarily with effect from 1/7/2020 till regular appointment of Vice Chancellor is made, or until further orders of the government, whichever is earlier. Now they are overriding the act. Here your Lakshmi kindly observe, or until further orders of the government. And underneath your Lakshmi kindly see by order and in the name of the Governor of Telangana.
Yes.
Therefore, my lord, my respect submission, his term expired on by 31st December 2022. The successor to be appointed another 6 months was granted. That expired on 30th June 2023. He is still continuing as the Vice Chancellor, or fourth respondent is continuing as Vice Chancellor.
It's 4 appeals for the fourth respondent.
Here, my respectful submission is this has to go to the second respondent, that is the Chancellor of the University, because it is not for the government to appoint the successor Vice Chancellor. The Chancellor of the University, that is the Governor, has to appoint the Chancellor. In the earlier proceedings, my lord, the Justice Sudhir, has deferred the issuing of notice until this court is. I'm under the impression that first this court has to be satisfied whether the governor has to be issued a notice or not. Therefore, that is the reason why I demonstrated all this to you. It is not for the other respondents to appoint the successor Vice Chancellor. The governor only has. I have read out again, my lord, if you are once. I read out the relevant portion. Who has to appoint the successor Vice Chancellor? It is the governor who has to appoint as per the act. Therefore, the state of Telangana and the other official respondents don't have any role. I am requesting, my lords, that the notice has to go to the second respondent.
Yes.
Not saying governor, madam. Chancellor.
This is judgment.
Yes.
So that's why I've made only chancellor. I have not said second respondent is governor. I've arrayed
Yes.
second
Who
respondent.
appears for the other respondents? Mr. Prabhakar. Yes. Yes. What do you have to say? What is the need for filing counter? Is the statute followed or it has been violated? Yes, friend.
Only request is kindly issue notice to the
Yes, right. Yes.
Item number 20, N. Naveen Kumar, G. Praveen Kumar, Deputy Solicitor General of India, P. Devinder, Anil Prasad Tiwari, Rajesh Kumar, P. Devinder.
Came for petitioners.
I beg to appear for the respondents 2 and 3 minutes. I am ready. Madam.
Yes. He has been admitted to hospital last night, which can communicated the same to standing loss.
Who has been admitted?
The arguing of the council on recording. I mean,
May I just point out 2-3 dates?
before I council may submit, I just point out to your lordship, there are only two parties before your lordship, the petitioner and the respondent authority. He has filed an intake got dismissed, went to Supreme Court also did not interfere to order, bring it to your lordship notice.
No, every time there is this issue, the Supreme Court has left it open for the victim to assess the prosecution and not the prosecutor. And they put that case, there is law on that. The assess the prosecution means that even oral arguments can be canvassed, even though arguments are treated. And the learned ASG has already granted no objection to be addressing the protocol. Let us point out a few dates, man. This matter come up on 18th.
Inability of the council, arguing council to be here, your lordship.
May I just point out with regard to that one. On 18th of October 2023, this matter came up.
Yes, when
It was pointed out that the sole basis of the interim order dated 21st of November 2021 was a stay in the predicate offences in the quash petition. The quash petitions have been dismissed on 30th of September 2023, that's 2 months back. At that time, what my learned friend argued was that they have engaged a senior counsel who is abroad. And that is why he sought date beyond the vacation. Learned ASG did not object to that. The matter came up on 31st. Now, on 31st, when the matter comes up, he says that we have filed SLPs challenging the order whereby the quash petitions were dismissed. And in that, one of the interim phrases that we are seeking stay on the execution of that order. So, ipso facto, if that is done, then the interim order will continue. And if it does not continue, then of course the matter can be taken up. The matter was showing as 3rd of November. That's why Lordship posted it today for final hearing. Now, my lords, the Supreme Court took up the matter on 3rd of November. I appeared for the complainants in that matter. There is no stay on the investigation which has been granted in that case. Today, there is an interim order which is subsisting for the last 2 years on the sole basis of stay on the predicate offences, which order today does not survive. So the only submission, what the learned ASG last time also pointed out, let the stay be vacated and let the matter be taken.
But I am only pleading for that, but nothing is going to happen. We are only going to continue the investigation. The only basis on which they wanted to stall the investigation is that the predicate offence is under challenge. Predicate offence brought, Lordship was pleased to consider it, and the petitions brought were dismissed. As against that, they went to the Honorable Supreme Court. There is no order of stay. And under those circumstances brought, there won't be any justification in continuing the interim order which they got in the present writ petition. The Lordship will appreciate that investigation has to go on as early as possible. For that, my lord, evidence is not lost. We will have to secure everything. We will have to, my lord, continue the investigation.
Yes.
should be the members of the bar and the council is not here and has been admitted to hospital last night.
They said they are going to engage a senior counsel, but I will never object, Lord, if it is the arguing counsel who is not well. But earlier their representations was that we are going to have a senior.
Yes, that was your representation last occasion.
Since past 4 days, he has not been attending court. I am not even in communication with him. His wife has submitted to me your motion. In fact, I know that they would raise this. I didn't got the medical records, and it's unfortunate that I have to prove it to the.
Lord, we will not doubt, Lord, the statement that the counsel is not well. They need not show the medical certificate and all. But then they should also cooperate with the court, Lord, and have a duty to the other side also.
Let the council.
Lordship may grant me at least 2 days time. The Lordship has
Taking into consideration the judgment of the Apex Court dated 13th September 2023.
be amounting to an ex parte order, your Lordship.
Arising out of the improved final judgment of order dated. Call the next case. List on, madam. List on 24th.
Item number 21, thereafter, GP for revenue, LA, Srinivas Reddy.
I'm okay. Arrest respondent.
Yes.
It's all day.
Previous matter. TSHC. తీసుకోండి vacate the petition and then council and others. Okay, madam. Appearing on behalf of respondents. I think first the water that makes reach that and the state treaty. Yes, I'll meet the group. Okay. Yes.
Well, a counter for 7th and 8th respondents, my friend, I said, time for reply.
Yes,
Will not take much.
For respond number 3 in the item number 22, we want to refer to the judgment that is of Federal Bank versus Sagar Thomas, 2003 10 SCC 733. My colleague is passing on the judgment copy. This is again in respect of maintainability of a writ petition against a private bank. But that paragraph number 32 and 33 are relevant.
May I submit my note?
Have you seen this judgment?
I have also got judgment. One is of the Karnataka High Court on the same issue of moratorium circular. Other is of Honorable Supreme Court. My lordship will peruse this. I want to place this. The nature of proceedings decides the maintainability of writ petition. If we are seeking the performance of a public duty, like this, in this case, we are seeking the implementation of COVID-19 circular, which was issued in the public interest. Then there is no bar to entertain the writ petition. And not only this, Honorable High Court, the Delhi High Court, Mumbai High Court, and various other high courts have issued directions on COVID-19. I placed that judgment. Kindly produce the page number 32 of my petition, 1183. Petition number 1183, page number 32, para number 20. This was the writ petition filed against the year back. Can I read, my lord?
Yes.
Reading the statement on development and regulatory policy issued by RBI on 27 March 2020, along with the regulatory package issued on March 27, 2020, prima facie shows that the intention of the RBI is to maintain status quo as on 1st of March 2020 with regard to all the installment payments for which had to be made post 1st of March 2020 till 31st of May 2020. The entire circular was described and it was interpreted by the Delhi High Court, Mumbai High Court, and Honorable this High Court also. Now, the nature of proceeding is of a public interest because the circular was issued by the RBI for the public benefit during the COVID-19. So, regarding those directions, there is no bar. If we would have challenged any surface the proceedings, then it could not be treated. And judgment is of Honorable Supreme Court is Garin Sharma. In this, they themselves, RBI, Union of India has admitted that we have introduced these schemes for the public benefit during the COVID-19, which were decided. And one is of Calcutta High Court, in which also it has been held. And the function is of a public duty. Then there is no bar to entertain the petition under section 226. And this is of Karnataka High Court or Pradhan High Court.
You were referring to the Supreme Court judgment?
Yes, this one.
This one?
Yes. They have admitted before the Supreme Court. That is not motion. That we introduce these schemes. And Honorable Telangana High Court also in 2020 have issued directions. This is of Karnataka High Court on the same moratorium circle, in which HDFC Bank was directed to implement. And RBI comes under the Article 12. This is state. All questions are answered in this. I reflect that question.
The judgment of the federal bank that I have passed on.
Yes.
That will deal with this. May I read? May I invite your attention to paragraph 31, Lord, exactly the point which is raised by my friend.
Yes.
The other case, paragraph 31, the second penultimate page. The other case which has been heavily relied upon is Andi Mukta. It is no doubt held that a mandamus can be issued to any person or authority performing public duty owing positive obligation to the affected party. The writ petition was held to be mandamus since the teacher whose services were terminated by the institution was affiliated to the university and was governed by the ordinances casting certain obligations, which is owed to that petitioner. But it is not the case here. Our attention has been drawn by the learned counsel for the appellant to paragraphs 12, 13, and 21 of the decision to indicate that even according to this case, no writ lie against a private body except where it has some obligation to discharge, which is statutory or public character. Then the next para. Merely because Reserve Bank of India lays the banking policy in the interest of the banking system or in the interest of monetary stability or sound economic growth having due regard to the interest of the depositors, as provided in Section 5C of a Banking Regulation Act, does not mean that private companies carrying on the business or commercial activity of banking discharge any public function or public duty. These are all regulatory measures applicable to those carrying on commercial activity in banking, and these companies are to act according to these provisions, failing which certain consequences follow as indicated in the Act itself. As to the provision regarding acquisition of a banking company by the government, it may be pointed out that any private property can be acquired by the government in public interest. It is now a judicially accepted norm that private interest has to give way to the public interest. If a private property is acquired in public interest, it does not mean that the party whose property is acquired is performing, discharging any function or duty of public character, though it will be so for acquiring the property. From the discussions held above, in our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligations or such obligations of public nature, casting positive obligations upon it. We don't find such conditions are fulfilled in respect of a private company carrying on a commercial activity of banking. Mere regulatory provisions to ensure such activity carried on by private bodies work within a discipline do not confer any such status upon the company, nor put any such obligation upon it, which may be enforced through issue of a writ under Article 226 of the Constitution. Present is a case of disciplinary action against, that is in respect of an employee of a private bank. Even that they said he can't enforce it through the writ petition.
Federal case was related
If it is his case that there is some violation.
and in this case said when there comes the question of public duty, that 226 can be invoked.
Complete it. If it is their case that there is some violation of some RBI circular or some statutory provision, but I have already pointed out in the counter affidavit that already an SCI is pending before the DRT. So all these questions are open for him to raise it before the DRT. That is number one. Number two is locus standi. Lord, the petitioner before Lordship is not the borrower. It is the company. Company is not before this court. This is the second ground I have raised. And I have raised this in the counter affidavit also. So on both grounds, there are three grounds on which it is liable to be rejected. One is maintainability of the writ petition against a private bank. Number two, proceedings are already pending before DRT. Number three, already the writ petition was filed earlier where they were relegated to a DRT to work out the remedies and under the provisions of the Securitization Act. So you can't raise grounds piecemeal. So it is hit by res judicata, constructive res judicata. Number four.
And there was specific directions at case number 69 to the RBI to implement the circular. So now
number four.
Considered
not completed it.
First of all, it was
Conclude. Yes.
Then the fourth objection is that it amounts to constructive res judicata. Having filed already a writ petition, having suffered an order. Now you can't raise grounds piecemeal, one after another. Then fourth ground I have raised is the locus standi of the petitioner, because he is not the borrower. Borrower is not before this court. And borrower is a company incorporated under the Companies Act. It has got its own entity. It's a legal entity. A director stands on a different footing. Rehearse the company. This is the fourth objection I'm taking. Fifth objection is that even assuming that there has been some violation of a RBI circular, according to us, there is no circular. This circular doesn't bind us. And this circular or circulars of all RBI are binding on us. But this particular circular has no application to the facts of this case. Therefore, whether this circular will apply or not, it's a question of fact. And this honorable court in a writ petition will not go into all this, more particularly when a tribunal is competent to look into all these aspects. And a tribunal is seized of the matter. And this issue is also raised in this SCA filed before the tribunal. They can't be allowed to raise the same ground before different fora. So on all these counts, the writ petition is liable to be dismissed. Concluded my arguments, my lord.
Yes.
Yes. Potential, whatever they are raising, that matters before DRT, sub-basic proceedings, questions, it's not a civil suit. Here we have come to invoke our fundamental rights, for which we were entitled during the COVID-19 period for our right to survival and to right to carry out our business. And now this circular which we are seeking of 27th of March, that itself was announced by the RBI to provide relief to those borrowers who were suffering during the COVID lockdown, because the entire business was totally collapsed. And to grant some relief, that circular was issued. It was not a statutory provision. It was issued for that specific period. Now, the implementation, the duty of implementation lies upon whom? The authority who has issued it. And to the authorities to whom it has been issued, that you have to implement. So, RBI is the generator of that circular. And because of that only, Honorable Supreme Court at page number 69 placed the order. It directed the RBI to implement the circular in its letter and spirit. Now, what was its letter and spirit? I have just now read the paragraph number 20 at page number 32. Further also, the various high courts on the same circular have interpreted that as per the content, if the borrower was fully serving the account until 1st of March 2020 and no installment was overdue, the borrower's account would not have been classified as a standard asset and there shall be no downgrade. So they turned our account NPA contrary to the circular of 30th of April 2020. If they would not have done so, our entity might be running smoothly. We were paying all the installments. Due to their non-action, non-implementation, our entity got closed. We suffered the loss of our infrastructure, around 5 to 10 crores. We suffered the loss. After that also, this circular was extended till August 2020, but there also no relief was given. So the duty encasted upon them, not upon the borrowers. Here is the question of fundamental right, not a question of fact or whatever the conditions with the learned senior counsel gave. Now DRT proceedings lies only in the surface yet. We are not at all challenging any demand notice. We are not at all challenging any possession notice. We are simply to implement the circular dated 27th of March. Likewise, at another page number, the Bombay High Court also at page number 36 of the petition 1183.
Yes, where was that apex court order?
Page number 69. Page number 69. Petition 1180.
Yes.
However, learned counsel for the petition submit that the circular dated 27th of March 2020 issued by the RBI has not been implemented by the banks. In view of the above, we direct the RBI to ensure implementation of the circular. Now, what remains?
Yes, anything further? Yes.
The reason that RBI has issued circulars during the COVID time to all the banks and for India. I refer to the 24.
We are dealing with 1183.
1183 only I am appearing.
He's also three circular. Circular.
Page?
Same circular which has been filed in earlier.
Yes,
challenge in all the three cases, 42, 43, and 24. Your lordship are pleased to see case number 530.
Yes, refer to 1180.
The circular starts at 21, the different portion page number 23 paragraph.
Yes.
Lending institutions shall then got board provide information reduced to all exhibit including the objective criteria for considering the fees under balance when disclosed to the public.
Yes.
The intention of the circular is that read to the eligible borrowers of the lenders. Borrowing and lending is a commercial transaction between the bank and the borrower. Whether the circular issued by the RBI and the board approved policy is very easy. As per the board approved policy, whether this borrower is eligible or not is a commercial decision should be taken by the bank. Once the commercial bank takes a decision, as per the board approved policy, he is eligible or not, the matter ends there. If at all the petitioners feel the board approved policy is not circular. Then the question arises whether the RBI circular is being violated or not. Second, if I'm a principal even till date, admittedly, it has not come forward to the RBI stating that there is a RBI circular violation. Under banking regulations in the Act, RBI plays the role of the regulator, where it issues guidelines from time to time, and it has statutory duties to monitor on quarterly or yearly basis as to banks comply with the regulations or not. In the interim, if at all any customer profile or customer finds a difficulty with the bank with regard to any complaint, it is for the petitioner to come into the notice of the RBI in the first place. He is straight away asked by way of petition. And insofar as the RBI role in this particular petition is concerned, is very limited to the role in this matter. I RBI does not have a role in this particular matter because it's a commercial decision taken by the bank which the petitioner has to face, whether it's eligible or not. And the RBI has no role to say that directing the banks to give them the credit facility or so on and so forth. And even the relief may not to the prayer is that to implement the ECGLS scheme. ECGLS scheme is brought by central government, Union of India. It is the Union of India to answer whether that scheme is being implemented or not. That is that maybe the Union of India will be able to answer. So far as the is concerned, if at all still the petitioner is aggrieved by the action of the bank, he may bring to the notice that it is to be examined whether the particular petition is in accordance with law or not. It is for the bank to decide whether this petition is eligible or not as per the board approved policy. Unless that decision is taken, RBI has no role.
Yes.
That whatever the interpretation of circular that has been done by the high courts, various high courts. Now they cannot discharge from their duty that they have issued this circular. They are the generator of the circular, they have to monitor that. And that was only the directions of the apex court. So up to that limited jurisdiction, we are seeking that he will submit a representation that shall be directed to the RBI. RBI either may forward to the respondent bank or whatever directions it want to issue, they may issue. After the final conclusion, we will see that what is their order.
Yes.
And another petition we have also submitted that petition number 16637. Only little facts are different.
Yes.
The moratorium circular. Petition number 16637. The moratorium circular should be filed till 31st of August 2020. After that, on 3rd of September 2020, the Supreme Court passed an stay order that till further orders, no account shall be turned NPA. Based on Article 73 of the Supreme Court. Regarding this, we filed a contempt petition before the Supreme Court. Supreme Court declined to hear the contempt petition, but directed us to approach to the Honorable High Court. After that order, we have filed this petition. The order is at page number 140.
Yes, who appears for the third respondent?
Conviction is that whether petition which my learned is arguing is based on circular, which is at page number 21, where it was to see I3 in both the cases as part number 3 is appeared. That's the back for the number I30 not in this. So I Five counting five. Five. Under this scheme of circular for March 26, circular which is a phase 1 year.
You're referring to your counter? No, you're referring to your counter?
No, I'm asking you to read the petition page 21, material basis of the petitioner, page number 21, which is the circular now, which is of March 2020.
Yes.
Page number 9 yellow, page number 23 yellow, paragraph number 9.
Yes.
May I read it?
Yes.
Now, wherever the exposure of lending institution to a borrower is 5 crores or above, as March 1st, 2020, the bank shall develop an MIS to release the credit. We shall intervene into borrower wise to credit facility wise information regarding these amounts for the relief grant. On this, the present outstanding according to the bank is only 1 crore and 9 lakhs. And this, for this relay, we have already answered by way of reply. I'll come to that, Your Worship. So therefore, March 27 circular is not applicable to the Axis Bank, Your Worship, because his amount is less than 5 crores. Now, Your Worship, he is relying on a judgment of the Delhi High Court. Now, Your Worship, he reads only the paras which are relevant to him, but he doesn't read the paras where Delhi High Court has clearly stated that this particular repetition is applicable only to that particular case. Your Lordship, you please to see para number 44 of the judgment, Your Lordship. Delhi High Court judgment. It starts at para number 24, page number 44. Of their material, I'm reading my
Yes.
Para number 44 years. 44.
Yes.
You are finding this, it is your material separate. You are finding this judgment. You are certainly just copying Delhi High Court judgment on which he was relying. Or he doesn't want to find that. That's the reason why we must not find it.
It is there in the papers filed by you in writ petition 5 and 2.
He is asking the para number 44 of that particular judgment.
Yes, Delhi High Court judgment I'm asking.
532.
You have filed this, sir. You have certainly the copy.
Para number 44 is number 44.
Para number 44 of the particular judgment, which starts at page number 24. Delhi High Court judgment.
Yes. Papers filed by you. You'll get it at page 62. Yes.
60 actually it is 60.
Subsequent papers are not numbered.
Yes. Okay, he wants to read only the para which are available to you. In this judgment, it is clearly stated that it is also clarified that this order will not serve as a precedent for any other case in regard to any other borrower who is in default or any other bank. Which of these cases will have to assess on their merits. Therefore, this particular judgment on which my learned friend is relying cannot be relied because there is a clear judgment. The judgment says that it is applicable only to that case. Your Lordship, thereafter the Supreme Court judgment. He has filed the Supreme Court judgment saying that page number 79.
Yes.
Page number 79. He says that, may I read it? Page number 79 of the topic. That is repetition number 825 of 2020. Rajendra Sharma's case, where he has filed.
Yes. Page 70.
79. Order. The request of Mr. Tushar Mehta Martin. Shall be at least 2 months. In view of the above, the accounts which were not declared NPA till 31/8/2020 shall not be declared NPA till further orders. This was on 31/8/2020, and this particular order was passed. That was only for a period of 22 months until further orders. Thereafter, the Honorable Supreme Court has passed a detailed order to what extent the NPA has to be declared. Now coming to my case, Your Lordship, you're pleased to see my documents, where NPA has raised all these issues. In the reply notice that has been issued by me, I have declared the NPA under section 13(2) by the under invoking Sanfasi Act. I request Your Lordship my documents in addition to my material papers. 532.
I don't have the copy of the contract.
One second.
His report was declared on 9th to 2021. What he was relying, was subsequently a detailed order was passed in November 2020. And he has been that action because that was exposure, that application was exposure. They were the it will be until further orders, this has to be extended. Thereafter, in November 2020, that particular petition of Gajendra Sharma was disposed of, with certain guidelines. And his account here was declared on 9 to 2021. And as I said, his loan account was below 5 crores. Therefore, he was not entitled for any, he doesn't fall under that circular which has been issued by the RBI. That's the second. Now, the third point, after invoking this notice under section 13(2) by the respondent bank, he has issued a reply. And in that particular reply, he has already challenged the circular here, for which a reply has been given. I have passed on that to the circular.
We'll continue soon after passwords and lunch motions today. Soon after passwords and we'll close the issue. Soon after passwords and lunch. Yes. Good afternoon. Yes, continue. Yes.
Item number 25, M. Rajalakshmi, G. Praveen Kumar, Deputy Solicitor General of India, R.K. Koteshwar Rao.
It's not been completely settled.
Yes, right. Not the counsel for the petition, counsel for the respondent, filed counter. List on 23rd finally.
Appeal for this one, petition, filed by K petition.
Publication is quite long. It is yes, it's quite copies out on the slow copies out on despite different. So what you guys see because the publisher is a matter of or there will come forward later if I when we make a mention, the case goes out of the list. It's not listed again. We have 3% in fact for the last 3 months. It says application is filed copies for service.
Sima.
There's no fine or pass verification. The applicant state, the state but they're not person not necessarily in other forums.
Then how have you filed it without serving the papers to the others? Yes. Is it 88290 or 882? Registry to verify and put up 88290 of 2023. Verify and put up the application filed USR number 88290 of 2023. It's from 9th. Yes. I said 9th. Go further adjournment. Yes.
Item number 27, M. Kirti, G. Praveen Kumar, K. Arvind Kumar.
There is an addendum order granted in this matter on 11/5/2023 at the weekend. Your leadership to have it tomorrow or the after tomorrow subsequent candidate.
Yes. There was a mention made for this matter. You made a mention for this matter. Just the council for the petitioner. You wanted it on 9th?
Or they are.
So 9th.
Right.
Yes.
Item number 28, PP Harsha G. Praveen Kumar, Deputy Solicitor General of India.
Yes. Thank you.
I beg to appear virtually in this matter for R3, my lord. Lordship may have it on Tuesday, subject to my lord's convenience.
A request is made for the matter to be taken up on 15th. 15th.
Obliged, my lords. Obliged. Yes, 15th.
Let's do on 15th. Yes.
Page number 4, item number 29 to 31, Challa Gururanjan, G. Praveen Kumar, Deputy Solicitor General of India, Srinivas Reddy K. Manoj Reddy, Kashi Reddy.
Madam, I beg to appear for the CCI, ma'am.
Yes.
Countable, readable. But everybody said.
Based on certain complaints. CCI had initiated some more things initially. But issued that order section. This is one. This is one of the directing investigation into the allegations of cartelization by the cement industry. What would really page 28. The petitioners are opposite parties who are subjected to investigation for pursuant to this particular order. There are a few of the response. Opposite parties for the second response. The page 28 notice this order. As per the section 26(1) of Competition Act. Page 28. Doesn't matter as terminated. Claims dispute by launch. May 19. There's an increase in cement prices and cartelization operating in various parts of India. That's the primary allegation. Kindly come to three. Some complaints of links to cartelization by cement manufacturers across India. Where others have specifically mentioned states, cities where this cartelization has taken. Some complaints are about meetings with cement manufacturers following which cement prices increased drastically. One such meeting was allegedly held on 29/3/2019, whereby decision was taken to increase the price of cement by so also. Then paragraph 4. Another meeting allegedly on 24/4/2019 again in Hyderabad, where it supplies and increase the rates by source. Then maybe after the complaints also, under the schemes of the Act. Kindly come to page 34 and paragraph 23. The 19th law expresses that there is a prima facie case for investigating for contravention of sections 3, 3. Accordingly, Commission under section 46(1) directs Director General to cause an investigation into the matter, complete the same within a period of 60 days of receipt of this order. Commission clarified that no names of certain civil manufacturers issued by the Commission which have been highlighted in the DT shall not be constrained by such names and shall investigate any one or such persons as described may have pledged in alleged conduct. This is the direction, but this order dated 1/7/2019. And now, page 36. There is another cost on 29/2021. The meanwhile, that investigation was going on. There seems to have gathered so much of information from all the cement manufacturers, including the petitioner. The petitioners are operating within the state of Telangana. They have registered offices here. They have manufacturing plants here. They maintain all their records within the state. So all the information, whatever was sought by the Commission or the DCB, has been furnished by petitioners from this particular state. And on page 36, this is the order pursuant to an application filed by now the consulting respondent here. That is not called respondent. Who has been now allowed to be included in these proceedings. They initially filed an application before a second respondent, but included as an informant. Pursuant to that application, this order can be large. This matter was referred to Director General for investigation by August 21. Passed up the section with the directions to submit investigation report. Their matter was listed before Commission. Considered application dated 7/12/2021. Kindly note the order issue was passed on 1/7/2019. Now they make application on 7/12/2021. Under section 18 and section 36, read the regulation 25, by which it has sought permission to be included as an informant in the matter and to participate in the proceedings before the Commission. Commission considered the aforesaid application filed by PI. Commission noted that matter is at an advanced stage of investigation. In view thereof, Commission is not inclined to accede the request made by PI to include it as an informant this day, and hence decided to reject the application. Their application has been rejected. But the reference is made to the treatment basic on which this application came to be filed. I take your logic to those provisions which section 1836 regulation 12. But this order has been challenged by PI before the deadline. Page 37 is the order passed in the session 8/9/2020, dated 56/9/2020.
Yes.
But TCI will oppose to this restriction. But saying that PI is not proper and it is not required to be included in the proceedings. Then ultimately, by referring to the relevant regulation at page 45. Kindly see page 44 parallel. Having noticed the regular submission, which have been addressed, firstly bear in mind the undisputed fact that after conclusion of investigation, Director General has already submitted a report which is to be taken up by Commission for consideration on 20th September 2022. Due in that light, it is evident that prior to the petitioner, to the extent that it sought to be included in the investigation, the court also notes that by rejecting application for impediment, which was made on 7th December 2020, Commission had taken into consideration the fact that proceedings Director General are an advance in the stage of investigation. Because in that backdrop, the Commission had declined the request made by the petitioner. It also notes that petitioner cannot strictly speaking have a direct interest in the investigation process, especially when it only speaks in the issues of information. Well, therefore, respondents may have been justified in taking the stand that petitioner not cause any damage of investigation. It was also coupled with the stage at which the investigation had reached. So, with this answer stands possible petitioner for following reasons. But reference is made with regulation 55. 1. This is the power of Commission to permit a person or enterprise to take part in the proceeding. The proceeding under which they sought to come on record by a impediment. So there is also my of this submission is that even this regulation was not followed in stricto sensu, because it contemplates the two conditions, satisfaction of two conditions. For one, he got brought on record in the ongoing proceeding. I just read 25 1. While considering a matter in an ordinary meeting, Commission on an application page which is writing if satisfied that a person or enterprises has substantial interest in the outcome of proceeding and that it is necessary in the public interest to allow such person to present his or his opinion that may permit or enterprise to present such opinion and take part in further proceedings of a matter which is specified. So they have to satisfy that the person who intends to come on record in the proceeding to establish substantial interest in the outcome of proceedings 1 and 2 that it is necessary in the public interest to allow such person to come on by expressing opinion. Then para 14, page 46. Undisputedly, upon conclusion of investigation of Director General of consideration, that stage it becomes open to any party person substantial interest. Outcome of proceedings are only able to establish that its presence before the Commission is necessary to public interest, to seek a right of audience before the Commission, and to present its opinion for its consideration. That is a right which is still open to be asserted by the petitioner. The court also bears in mind the fact that the report that may be drawn by Director General is neither determinate for the Commission to take all aspects, including views that will be expressed before it in consideration before passing final. Both regulations 21 as well as 25 thus provide an opportunity to parties to address all submissions for its consideration. In view of the court finds that not only will it be open for petitioners to apply to the Commission in terms of regulation 25 and to seek a right to address submissions, it is also open and advise under the prayer for being provided a copy of investigation report or the extracts thereof. Ultimately, interest of bodies like the petitioner is limited to providing institutional information, which may enable it to come to a just conclusion. Since the right is still available to be exercised, finds no justification to issue any directions. Or to observe that it would be open to the petitioner to under regulation and to address all issues before the said body. Consequently, restriction along with pending application shall stand accordingly disposed with liberty to the petitioner resolved to oppose that extent. Matter is stated to be posted before Commission on 28th September. Shall be open to the petitioner to apply to the Commission prior to the opposite date. Any such application may be ultimately made by petitioner, may be considered by commission in accordance with. But therefore, they again go back to the commission, basing on the liberty which has been granted. But here, the earlier I could say, earlier application virtually has rendered exemption. Then it says that under 25, they could have gone before the commission and their application under 25 can be considered in accordance with it. Subject to satisfying the requirement of 25. Now, their application has been filed. It's a page 40. But pursuant to that application, kindly come to page 70. Application was filed on immediately next day, 7/9/2020. Before that application came to be considered, an order has been passed. I'll just read that order. 10/2020, page 70. Page 71. Kindly come to page 70. The commission considered the application dated 27/9 filed by PI under section 18 forms of law, seeking permission to be included as a party and to participate in the proceedings before the commission in the present time. That the previous facts have been narrated in 2, 3, 4, 5. Kindly come to the consideration part of section 7. Because this all submissions of PA have been extracted from 2, 6.
Yes.
Having considered the request made by PA's application, commission is of the view that PA may be provided a copy of the order. They have not come on record still, but even before that, this order has been passed. PI may be provided a copy of the order dated 1/7/2019 passed by the commission under section 1 and non-confidential version of DC report dated 1/7/2022 submitted by the DC. Commission directs PI to present its opinion, if any, in writing in the matter within 6 weeks of the receipt of this order. Secretary is directed to forward a copy of this order to PI and opposing parties to their respective authorized representative. Secretary is also directed to provide soft copy of the order dated 1/7/2019 and the non-confidential version of DC report submitted by the DC. But they sought for implement. Even before they have been implemented, Commission says you give these documents first to them. Then we will see later on, consider whether they are required to be implemented or not. A very strange procedure has been followed. Now, after this impute order came to be passed on 5/7/2023, almost after 8 months, more than 8 months. Page 23. Page 23, kindly come to 24. Matter was listed today to consider application dated 27/9/2022. The day seems to have filed some other application also for providing these copies. That's also, and also for inspection. That two says permission to include as a party and to participate in the proceedings in the present matter in terms of resolution. Then 3, 4, 5, 6 are verbatim same what the lordships have seen the contentions raised in the previous order dated 6/10/2022. Then paragraph. While order dated 6/10/2022, Commission had considered the application of DA and decided to provide a copy of the order passed under section 26(1) and non-confidential version of investigation report to BIA. Commission has further directed BIA to present its opinion in 6 weeks. Okay. On 21/10/2020, BIA filed an application seeking inspection of public non-confidential records under Regulation 51. Further, BIA filed another application dated 27/10/2020, seeking copies of non-confidential versions of replies, responses, objections filed by various opposite parties in the present matter to allow it to provide appropriate submissions. 4 set applications were placed in the ordinary DP. Then some other applications to be filed by opposite parties that has been extracted in paragraph. Kindly come to paragraph. First, the Commission considered the 4 set applications filed by BIA and opposite parties and stated supra. At the outset, Commission observed Regulation 45 points as follows. 55 has been extracted, which I just related to about. Then consideration is from 30. The only 30. On an overall appreciation of the reasons mentioned by BIA in its application, Commission is satisfied that BIA has substantial interest in the outcome of proceedings and that it is necessary to allow it to present its opinion in the matter for a meaningful length. Implement application is thus allowed in terms of and is made a party to matter henceforth. Further review of aforesaid direction of Commission regarding implement request made by BIA in its application dated 21/10/2020. May be allowed to inspect all confidential records in the matter. In terms of Regulation 37, accordingly, applications are disclosed. Review of the above, BIA is directed to file its opinion on investigation report, if any. BIA is also directed to serve upon each OP an advance copy of its opinion, along with its implement application dated. They ordered implement. After that, they wanted that implementation to be served on us. Filed by it to the Commission with an intimation to the Commission. OPs are at liberty to furnish their replies to respondents. So this order is in challenge before you. But the order is challenged to essentially, but first ground is that CCA, when an application has been made for complete come on record in a proceedings, that proceedings relate to an investigation proceeding, where confidential data has been shared by all the industry to the CCA for the purpose of conducting investigation that is not in public domain or not available. It's a information or documents submitted as some confidentiality. But now that is sought to be accessed by way of coming on record into the proceeding. So the opposite parties' interests are substantially involved. So therefore, the Commission ought to have the moment and the very same Commission in 2021, when such a similar application has been filed, it said that the investigation is at advanced stage. Therefore, it has rejected that application. But now, the subsequent second application, first Delhi High Court said to consider it in accordance with law, particularly with reference to Regulation 25. The minimum required was that Commission ought to have issued notice on this application, put on notice to these opposite parties who have shared all their confidential data and information to the Commission for purpose of investigation. Before somebody is brought on record into the proceeding and giving access to them, access to all that information. That is not first submission, but that there is a clear violation of national justice without issuing the case. But they could not have directly instituted this proceeding. Then, secondly, the Lordships have seen 6/10/2022, they filed an application
6/10/2022, my lord, order has been passed, giving my lord access to the order and also to the report. They have not even been my lord allowed to come on record at that stage. That an order has been passed already permitting BI to access to my lord the records, and later on now BI official says, I am considering the application for improvement now. Lord, it is order dated 5/7/2020.
Yes.
Lord, therefore, Lord, it is valid. Lord, then the reasons which have been given at page 27, C, that's the only reason, Lord, what has been given. Absolutely, Lord, this doesn't construe to be a Lord reason. And a speaking order.
Yes.
The recording of reasons while passing any order, that is essential and not free to say if somebody's rights are affected. That this order doesn't record Lord any reason. Much less Lord the reason what it is required to give in the teeth of Lord Regulation 25. Lord, what is see Regulation 25? But once again, for my benefit, it is there.
Yes.
Considering a matter in an ordinary meeting, Commission on an application made to it in writing, if satisfied that a person or enterprise has substantial interest, your satisfaction should be with reference to substantial interest in outcome of proceedings, one. And secondly, that it is necessary in the public interest to allow such person or enterprise to present his or its opinion in the matter. We are now coming to paragraph 13. It only reproduces the requirement of having a substantial interest, but it doesn't deal with the public interest involved. What kind of public interest is involved if this BI is not brought to record into the proceedings? When Commission thought Lord in 2021 that it was the BI was not at all required to be brought on record. It also said that the investigation was on advanced stage. But now in 2023, much water has flown. Now the investigation is complete, report is out. According to them, report is also submitted report. But now at this stage, if this application is to be allowed, that there should have been justification and with proper reasons as to why AI should be permitted to come on record, particularly in the context of 25. That for support of is the regulars. May kindly take we rejoin the pipeline. Phase 1.
Richard.
Yes. You're referring to Rajesh Agarwal's case? Yes.
Context of silent itself. They can apply the need to observe. Yes. Practice where it is administrative proceedings, you can trials, system, you get possible. This was in the context of master elections on courts. It's addressed by RBI, where there was no function for issuance of notice before they are declared as in that context, is a key part. But here, nowadays also, there is no opportunity given to file for any response to take the check. And clearly, it is amounts to the violations. That's right. Relating to the supporting the order by reasons. Based on 2010 SEC 742.
Page 73 of the paper?
Yes.
Yes.
This year versus steel and concrete. And T4. But this was in the context of section 26 of the Competition Act. In that context, an order was passed directing investigation.
Yes.
That order was right now. The acute judgment has taken the view that there is requirement to record reasons which can be explained or in any case followed by necessary implication. Therefore, authorities required to record reasons for coming to the conclusion. The proposition of law, whether an administrative or quasi-judicial body, particularly judicial courts, record reasons in support of their decisions or orders, is no more less in the ground has been settled by recent judgment. TCT versus Shukla. And this court was primarily concerned with the High Court dismissing grounds for recording any reason. Court also examined the practice and requirement of providing reasons for conclusions, orders, and directions given by the quasi-judicial and administrative body. The Shukla has been factored at paragraph 95. Next page, at page 115, just beneath that, it is very different. This court, by referring to the decisions of this court, held that it is essential that administrative authorities and parents record parents leading to the order. Record explicit reasons in support of the order later. Then you are para 97, number 6. The above reasoning and the principles enunciated which are consistent with the second canons of appeal in this case. The background of these determinants we may refer to HIGHCOURT Act, Section 26 under different subsections requires Commission to issue various directions, take decisions and pass orders, of which are even appealable before trial. Even if it is a direction under any of the conclusion or order passed on merits by Commission, it is expected that same will be supported by some reasoning. At the stage of forming controversy, as required in section. Commission may not raise a report detailed date, but must expect it 90 to 1% terms that it is requiring issuance of direction for investigation. Such views should be recorded at the Commission. The opinion should be formed on the basis of records in the Parliament information from this various provisions of that. However, other decisions or orders which are not directions solicitor and determining the rights of parties should be well reasoned, analyzing and deciding the rights and raised before the Commission by the parties. In other words, Commission is expected to express right of issue in terms of without entering into any adjudication or explanatory process, and by recording minimum reasons substantiating the formation of such opinions, while all its other orders and decisions should be well reasoned. But I emphasize this: the 26(1), there is an order under 26(1). Even that also, the judgment says that there should be reasons. The extent required, but if it's an order other than 26(1), but then that order decision should be well reasoned. Here, the power that is exercised for allowing DI to come on record is Regulation 55. So, Regulation 55 itself enumerates the requirements for a person to come on record to the proceedings, ongoing proceedings. So, therefore, there should be well reasoned reasons. But other than these two, that violation of justice, I will no reasons. But the subset of the second argument that the regulation certified twin conditions those twin conditions that are lacking, and those that the Commission does not address taking out of a case based on those two twin conditions. Even assuming for the sake of argument that it had proceeded to consider the application without even notice to the affected parties, but still the Commission should have satisfied for itself that those two conditions are applied. Commission doesn't even address to the second condition of having public interest. That this BI is only an association of builders. So it should have considered what exactly is the public interest involved in case BI is not permitted to come on record with the city. That too, having rejected its first application at first application in the first instance. Therefore, there is a much more high degree of consideration required when the second application is entertained. Ultimately, Delhi High Court only said that you consider the application in accordance with law. But they will have to pass the test of Regulation 25. If at all they are satisfying the 25, then only they should have been permitted to come on record.
Yes.
But this is on violation of principles of this one non-recording of it. But so far as the merits are concerned, because this is an investigation exclusive to the information which the opposite parties are driving. there is something called confidential. But not that everyone can come and straight away get included into the proceedings and have access to this information. But there is a provision in the regulation, that is a regulation, the Act, section 57. Because there was no other third party, but all the information which has been shared by us, this is on merits of the matter. All information has been shared by us. But we could not qualify something to be confidential, something to be non-confidential. Because there is nobody in the proceeding, no third party, outsider is involved in the proceeding. Occasion to flag what is the confidential, what is non-confidential, that stage has not come. So therefore, our rights under 57 are also affected. Because now access is being given to all the information as if everything is non-confidential. That is what merits of the matter. How we are affected, in case they are brought on record. All these we could have said before the commission. If at all had we been given opportunity and notice their agreed application, we would have brought all these things to the notice of the commission, and commission would have considered.
Yes.
But we are deprived of that opportunity.
Yes.
Therefore, in my respect to submission, this order has to be sustained. And the treatment picture is liable to it.
Yes.
I beg to appear for the CCI, my lady.
Yes.
I heard my learned counsel for the petitioner. In this petition, they are challenging the impugned order dated 5th July 2023. I'll keep my submissions very brief. Am I audible, my lady?
Yes, yes.
I'll keep my submissions very brief. All these contentions, the cement companies. Let me take a step back and say why the impugned order has come. This is a proceeding under the Competition Act 2002. If my lady has a copy of the Competition Act, Lordship may kindly see the preamble to the Competition Act. The job of Parliament created this body called a specialized body called the Competition Commission of India. The objective of the Competition Commission of India and the purpose of the Competition Act is to ensure that whatever are the obstacles to free and fair competition, the job of the CCI to remove them, is to take action against people who are forming monopolies and cartels and hurting consumers. Lordship, my lady may kindly see the preamble to the Competition Act.
Yes.
An act to provide, keeping in view of the economic development of the country, for the establishment of a commission to prevent practices having adverse effect of competition, to promote and sustain competition in markets, to protect the interests of consumers, and to ensure freedom of trade. This is the objective of the specialized body created, like SEBI, which protects investors. We have our job, the CCI's job, is to ensure protect competition. That's the reason for which this body has been created. Now, the current proceedings have been initiated because the CCI has received several complaints against the cement industry. One of these complaints, and we formed a prima facie view that these cement companies, what they are doing, like at least it's all prima facie, based on the complaints that we have received, they're forming cartels. So cement companies form cartels and they're raising the price of cement. As my lady will understand, if the cement prices is raised, then the builders will buy cement at a higher price. And if builders buy cement at a higher price, then they will build the houses even for small people at a higher price. Essentially, for a small man, on the ordinary man, the cost of buying a house will increase when cement companies come together and form a cartel and raise the prices. So this is the investigation which we are doing. We found a pattern where the cement companies are increasing the prices of cement. And because cement companies raise the price of cement, builders will raise the price of houses. When builders raise the price of houses, ordinary man will have to pay a higher price for houses. So the ordinary man on the street is getting affected by the cartel being formed by the cement companies. That's why CCI had to take on this job and investigate the cement companies. But the investigation was going on. As a part of the investigation, there is a moment we do the investigation, my lady, the Competition Commission of India regulations state that any person who has an interest in the proceedings can apply to the CCI and can get information. But my lady may kindly see Regulation 35. My learned friend has referred to it, but I think it's the, just want to emphasize the correct provision. Regulation 35. Sorry, Regulation 37, madam. I'm sorry.
Yes.
My lady may kindly see 37.1 and 37.2. May I kindly see the difference between 37.1 and 37.2. Subject to the provisions of Section 57 and Regulation 35, a party to any proceeding of an ordinary meeting of the Commission may, on an application writing in that behalf, be allowed to inspect or obtain copies of the documents. So, not any party to any proceeding, if he writes a letter to us or makes an application to us, then he can inspect the copies. This is a party to the proceeding. Lordship may kindly see clause 2. May I read clause 2, madam?
Yes.
I'll read slowly. The Commission may, on an application of a person who is not a party, my Lordship may kindly note the phrase, who is not a party to the proceeding, on sufficient cause demonstrated, allow such person inspection of the documents or records mentioned in regulation on payment of a fee as specified. So any person who is not a party to the proceeding, on sufficient cause, he can allow to inspect the proceedings. Now, here we are investigating the cement companies. As I've explained, my lady, if the cement companies form a cartel and raise the prices, the first victim is the builders and then eventually the consumers. So the Builders Association came and said that we want to inspect their documents. We allowed them to inspect the documents, but very important, we allowed them to inspect only the non-confidential version. We did not let them touch the confidential version of the documents. In fact, my lady's interim order also specifically said, if my lady recalls, my interim order passed by my lady in this proceeding specifically says they can have access to non-confidential version. And we followed it and we gave access to only the non-confidential version. So, and this non-confidential version, my friend said, no, it hurts them. This non-confident, the very fact that they're non-confidential means that no prejudice would be caused to them. In fact, their other competitors also saw their documents. So the petitioners have not spelled out what is the unique prejudice which they suffer when other people can see the non-confidential documents, but Builders Association sees they have a prejudice. My friend has argued a lot on natural justice, but the Honorable Supreme Court has also said there's something called useless formality. Principles of natural justice will vitiate only if they cause prejudice. Here, my learned friend has not spelled out any reason as to why sharing non-confidential documents will cause prejudice to the petitioner when the very same non-confidential documents have been seen by his other competitors. I ask a question, if builders see what is the problem and if other competitors see why is there no problem? So that's my first proposition, my lady, is that we have given access only to non-confidential documents in accordance with Rule 37. And my second proposition, Rule 37 does not require to be any hearing to be given. Any person who comes and files, who has a sufficient cause demonstrate, and we have followed that procedure.
Yes.
My third proposition, my lady, is that my friend, is that the interim order is a well-reasoned interim order. Sorry, not interim order. The impugned order. The impugned order is well-reasoned, and the facts speak for themselves. Milord, what is the reasoning that he wants, Milord? As I said, Milord, this is a cement. I'm investigating cement companies. When cement companies raise their prices, the builders are the victim. The builders have come and filed an implead application and said that we are charging higher prices to the ordinary man on the street because cement companies are charging us high price for cement. So if they double their price, I have to double the price of the house. So we have a right to please hear us in these proceedings. And the only condition in regulation 25, Lordship, my lady may kindly see regulation 25.
Yes.
While considering a matter in an ordinary meeting, the commission on an application made to it in writing, if satisfied that a person or enterprise has substantial interest in the outcome of the proceeding, and that it is necessary in public interest to allow such person or enterprise to present his or opinion in the matter, may permit that person or enterprise to present such opinion and to take part in the further proceedings of the matter as the commission may specify. So all that the commission has to do is that if any person has a enterprise or has a substantial interest in the outcome of the proceeding, and if it's in public interest, I ask a question myself, my lady, whether when I'm investigating the competition commission, sorry, when I'm investigating the CCI is investigating the cement companies, the Builders Association of India has an interest in the outcome of the proceedings. If I investigate and find that the cement companies are actually forming a cartel and are fixing high prices, the Builders Association will benefit, will have a say in the proceedings because they are the people who buy cement from the cement companies. So I have not heard, I've carefully heard my friend, but I've not heard any credible argument by my learned petitioner's counsel as to why the builders will not have an interest in an investigation into the cement companies. We are not investigating cement companies or something. We are investigating cement companies for the simple issue that you're fixing high prices. And the consumer of those high prices is the builders. So how are they hurt if the builders are hurt? I have not heard what is the special injury which they have suffered. So my third proposition to my lady is that they have not demonstrated any prejudice they would suffer if the cement companies, so if the builders are hurt in investigation against the cement companies.
Yes.
My lady, for this, and thankfully to lessen the burden, my lady, this is not the only writ petition filed against on this issue. Cement companies who are being accused of forming a cartel, they have filed writ petitions across the country, in Rajasthan, Madras, in Delhi. In all of them, they've gone across in 3 high courts. Cement companies across have filed writ petitions challenging the very same impugned order on the very same grounds on the very same issue. Identical grounds, identical impugned order, identical issue. The Delhi High Court will not reserve the judgment. They have not given a stay. The Rajasthan High Court refused to give a stay. The Madras High Court single judge dismissed the writ petition. They went on appeal before the division bench. The division bench also has dismissed the writ petition on merits. With your kind permission, I would like to place the division bench of the Madras High Court. My colleague is handing over the Madras High Court order.
Yes.
My lord, if your lordship may kindly see the para 2. Para, my lord, the para 1 itself, my lord, it gives a very short. My lord, this judgment will make, in my utmost respectful submission, it will make your lordship's job quite easy. The
Yes.
Competition Commission of India, under Section 26(1) of the Competition Act, ordered to issue suo motu notice to analyze the complaints received by it against various cement manufacturers. The complaints were on account of steep rise in the price of cement. It directed the Office of Director General of the Competition Commission of India to investigate the complaints and further to determine whether the cement companies had committed any act in contravention of Section 3. Well, Section 3 says, Section 3 of the Competition Act says that, Lordship may kindly look at Section 3. It's called anti-competitive agreements. The concern was that all the cement companies grouped together and then they formed a thing saying that we'll fix one price, a high price. I'll read on. Pursuant thereto, the Director General of the Competition Commission of India conducted the search and seizure and he initiated the investigation. Next paragraph. Para 2. It appears that on 7/12/2021, the Builders Association of India, in short referred to as the BAI, filed an application before the Competition Commission of India for impediment. It sought to be impeded as an informant, claiming it has sufficient interest in outcome and is a necessary party in the suo motu proceedings. The application was dismissed by the first respondent by order dated so-and-so. The BAI challenged the said order before the Delhi High Court by filing a writ petition. The Delhi High Court, under order dated so-and-so, granted liberty to the BAI to move the Competition Commission of India under Regulation 25, hereinafter referred to as the regulations, and directed the Competition Commission of India to consider such representation in accordance with law. The BAI on 27/9 filed an application for impediment as a party in the said suo motu proceedings. On or about 5/7/2023, the first respondent allowed the application filed by the BAI. The same was assailed by the appellants before the learned single judge of this court by filing writ petitions, so-and-so. The learned single judge of this court, and the impugn order dated so, declined to exercise its jurisdiction on Article 226, both on the grounds of forum non-convenience as well as committee of courts. It was observed by the learned single judge that Delhi High Court is positioned with all jurisdiction to take cognizance of the dispute raised before it. As regards the very same impugn order, now being challenged as writ petitions, it's observed by the learned single that the Delhi High Court has heard the matters at length and reserved judgments, while this court is yet to examine the case on merits. It appears that the order assailed by the present appellant before the learned single judge was assailed by another cement company, Ultratech Cement Company, before the Delhi High Court. But identical order challenged before the Delhi High Court. Delhi High Court heard the matter and reserved judgment. In light of the above, the appellants have approached this court by filing the present appeals under the provisions of the letters patent. But I'm not going to read the submissions, but lordships may take it from me. All the submissions earned by my petitioner's counsel have been urged before the Madras High Court single judge and division bench. The findings start from para 9.
Yes.
We have heard the submissions canvassed by the learned counsel for the parties, the respective counsels, so and so. Para 10. On 25/8/2023, we have heard the learned senior counsel for the appellants and learned counsel for the respondents on the issue of jurisdiction, as well as merits for the impugn order before so and so. And then they said they're giving a finding on merits. Next page, para 11 is where they start.
Yes.
The proceedings under the Act of 2002 would be proceedings in rem. Under Regulation 37(2), the Commission may, on the application of a party who's not a party to the proceedings on sufficient cause demonstrated, allow such person inspection of documents mentioned in Sub-Regulation 1 of Regulation 3037. under sub-regulation 1 of regulation 37 of the regulations of 2009, a party to any proceeding on the ordinary meeting of the commission may, on an application writing in their behalf, be allowed to inspect or obtain copies of the documents or records submitting proceedings subject to the provisions of section 57. In para 12, regulations 35 of the regulation mandates the commission to maintain confidentiality of the identity of the informant. And under sub-regulation 2 of regulation 35 of the regulations, a party may submit a request in writing to the commission or director general, as the case may be, that a document or documents be treated as confidential. Next page, Manoj. The procedure is prescribed as to how the confidential documents are to be marked under sub-regulation 8 of 35 of the regulations. At the request of parties, the commissioner, the director general, if satisfied, shall direct that the document or document shall be kept confidential for the time period. As such, kindly note this phrase, as such, the right available to the parties is also available to any person who is not a party to the proceedings to allow inspection of documents. Any person, even an ordinary consumer, can go before the CCI and say, I'm interested in the outcome, I want to examine the documents. CCI is bound to give the documents. Here, what we have done to protect confidentiality is that we said we'll only give access to non-confidential documents only. Now, para 13. The apprehension of the appellants in implementing BAI is that BAI was not a party. They may not have marked some of the documents as confidential documents, and the impediment of the BAI would have prejudiced them. In view of the fact that may not have marked some documents, the BAI will have access to it. In fact, BAI can be categorized as a person as per the definition of person under section 2. The BAI was also allowed to inspect all the documents as per the condition of the BAI on 5.7. It was also provided with a non-confidential version of the Director General report under the order dated so and so. The appeals are filed by the respective appellants on or about 16/8/2023 and 21/8. Prior to the filing of the appeals, the BAI is already provided with the inspection of the documents. In view of that, the entire premise of the arguments of the appellants, the inclusion of a BAI as a party, it would have access to inspection of documents, would now be futile. But the only reason which my learned friend was saying is that, and his repetition also was saying, is that if BAI is made a party, it will get access to documents, but it has already got access to the documents. And only the non-confidential one. But next paragraph, para 16, no doubt, before passing the order of impleadment, the Competition Commission of India ought to have given notice to the present appellants. The learned judge records that. That is the minimum requirement of the principles of natural justice. This is what my friend is emphasizing. However, as the matter has proceeded further and BAI has already been given inspection of all the documents of the appellants as contemplated under regulations of 2009, now nothing would survive for the appellants to agitate. I'm making the same argument here also, that their only articulated prejudice is that if BAI is impleaded, they will get some documents. Our submission is that whatever non-confidential documents have already been given to them, have already have access to it. So, therefore, this is an empty formality saying that they should be heard before being impleaded. In light of that, these appeals stand dismissed. And as on merits, we have not entertained the appeals. We did not consider the aspect of jurisdiction, including that of forum non-convenience and comity of course. My respectful submission, Milord, is that. No, so this is the division bench judgment against the same. I'll not show the single. The learned single judge said that Madras High Court is not the appropriate court. It's a Delhi High Court, which is a more appropriate court. Milord, in our pleadings, we have also taken the plea that. Well, I'm not going to say that this honorable court. I'm not making the argument that this honorable court does not have jurisdiction, but I am saying that the Delhi High Court is a more appropriate court for this matter because the entire issue of Builders Association, everything was argued extensively before the Delhi High Court, and the matter is already reserved over there. And the petitioner should have approached the Delhi High Court in this matter. Well, that's my final submission. The important point here is, Manoj, that what is confidential, non-confidential was decided by the parties themselves. It's not that more than CCI, it is the parties which had played a primary role. The cement company itself decided, they themselves marked as what is confidential and not confidential. Kindly see, my lady, their petition. What is the grievance articulated in the petition? This is the only reason, page 14. Page 15, Manoj, is the fourth line from top. The second respondent, my lady has it. The second respondent here is the CCI. By allowing participation of additional informants who evidently lack substantial interest in the case, would enable and encourage undue access to case records by unrelated third parties. The contents of the proceedings, including the non-confidential case records, is not available to the public at large, owing to the sensitive nature of the proceedings pending adjudication by so-and-so. Further, while certain information will be non-confidential qua the regulator, the second respondent may still contain commercially sensitive information qua third parties. Access to such records to an unrelated third party may have the potential to severely harm the petitioner's right to conduct business. How the petitioner was unable to put forth this contention. But this is the only point which they're saying, that if these builders associations made a party, they'll get access to documents, and even if they're not confidential, we don't want them to see. My short answer, my lady, is that they've already got access by virtue of orders of various courts, including this court. We have protected them by not giving them confidential documents. And three, what I don't understand, which my petitioner's counsel does not answer, is that this very same documents he's very comfortable, is competitors looking at it, but he does not want the builders to look at it. This is what my thing, Millard, is a very quite inconvenient and quite conspicuous. Like, why is he worried if his competitors are okay to see these documents, but he is apprehensive only if the builders can see the documents? Millard, so in any case, Millard, this injury has become infructuous because they already have access to the documents. I'll conclude, Millard, by just showing the sale judgment itself. The Rajesh Kumar Agarwal, which my learned friend has shown, arises under the RBI Act. With respect to natural justice, it's there under the... Lordship may kindly see page 109 of the writ petition. This is 2010 SEC. My learned friend has also fairly referred to it. I'm grateful for him for enclosing 2010 SEC 744 at page 109.
Yes.
Page 109, para 79. It is difficult to state as an absolute proposition of law that in all cases and at all, it's difficult to state as an absolute proposition of law in all cases, at all stages, and in all events, the right to notice and hearing is a mandatory requirement. Lordship may kindly note that phrase. Furthermore, that non-compliance thereof would always result in violation of fundamental rights, vitiating the entire proceedings. Different laws are provided for exclusion of principles of natural at different stages, particularly at the initial stage. So, Supreme Court said that it's not mandatory to provide notice in all cases. Manoj, I'll conclude my submissions by making this, summarize my points, Manoj. Number one, that we already protected him by giving the non-confidential version. Two, the builders have an interest in the proceedings because they are a victim. Three, no prejudice is being suffered. And four, the Madras High Court has already dealt with this matter extensively, and both the single and division bench have already dismissed the matter. I respect, although the Madras High Court judgment is not binding, I think the reasoning is quite authoritative, my lord, and I humbly urge my lady to follow the same reasoning as the Madras High Court. I'm very grateful for a patient hearing.
All the three matters? All the three matters?
Yeah, all the three matters. We'll give a short note also, my lady, on once my learned friend concludes.
I'll hear you on 10th. I'll hear you on 10th. Item number? Give it to the court officer. Yes.
Very close to value also. Please calculate for 20th or 21st of November and inform the other side.
You have informed?
I will inform you. And inform it 20th. I will inform the other side.
You inform the other side, and if it is convenient for all, we'll post it on 20th. And then get back to me at 4 o'clock. Get back to me at 4:30.
Item 20, as per Supreme Court's order, and passed on the order, your lordship consider that Supreme Court specifically said, not to arrest, investigation may continue as your lordship indicated. Lordship will take that order.
You passed. Yeah, I'll look into that. Yes, that was the order which was given in the morning. The same order. Yes. This was what it was passed on in the morning.
Okay. I apologize to the lordship that nothing could not appear and I could not make that issues.
Yes, I have told the court officer to extract the entire order in the copy of the order.
There are no coercive steps in this.
I have brought it on record. The very order of the apex court. Yes. Yes, your colleague is here. Yes, you first inform the other councils who were there in the morning. They are not aware of this change. Keep them informed and then let your colleague make a mention. Yes. Yes.
Lunch motion. Page number 1, item number 1, in this law form, GP for school education.
Matter is coming up for other side. Second respondent.
Yes.
Your lordship, the school management is not taking transfer certificates from the parents' lordship. They are admitting the students in the school, my lordship. So we have MBO office, we have child info, my lordship. In that info also, whenever we are mentioning those names, it was reflecting old school only, my lordship. This is the thing happening over here, my lordship. And kindly look into the third page, my lordship. Brilliant Grammar High School given the letter DU of my lordship, stating that last slides. So we request you please give 20 days time for obtaining thesis. If we are not able to get thesis, then yes, from parents, we will be liable for the action.
But all this are mentioned, my lord, by way of repetition. The reason, my lord, the reason for my lords not obtaining transfer certificates, as I've indicated to my lordship, only 60 students among 900 students are studying this school. Only 60 students could not submit their transfer certificate because one particular school was not issuing the transfer certificates. They do not target that school, they do not ask them as to why they are not returning the transfer certificate despite the parents who want to join their kids in other school. That they do not target. They file a writ petition, attached to the writ petition order copies.
The parents of the students filed a writ petition. My lords may see the copy of the order in page number 36, my lords. Starting at 36.
Yes.
I may take, my lords, there is only one dispute, my lords. One particular school has not issued, my lords, the transfer certificates to the students, taking the hapless situation into consideration of the parents. Though they have requested, they have stated that they will submit, but the other school was not returning the certificates. My lords, only they ought to have taken, the respondent ought to have taken action against that school, my lords. One proceedings has not been issued to them. The parents of the school filed.
The written instructions passed down to the court say that this is going on for the last more than 1.5 years.
Which no, my lords. My lords may take the page number.
Let them file their counter.
Not my lords, the school is closed down. In the middle of the year, they've closed down the school. That is the urgency. The students are not able to go anywhere. Because of the 16 students, 900 students are suffering, my lords, now. They've closed down the school apparently. The class closing orders, where will the students going between the academic year, my lords? My lords may see page number 36, 24 students have approached this honorable court. The 24 parents of the students have approached this honorable court. This honorable court has passed orders.
Page
36, my lords.
Yes.
Page number 36 of my report. These are 24 parents, my lords, who filed against the Siddhartha High School. Valid as respondent number 6 here. From these school only 60 students are not able to get transfer certificate. So the order was, my lords, may read 37 page. Last paragraph, my lords. In view of the same, my lords, last second paragraph, held by this court and several other courts in canton of decision, 6th respondent management cannot withhold certificates for non-payment of fee by the petitioner. 6th respondent does no lien or the certificates of the petitioner for non-payment of fee. In view of the same, the petitioner shall approach 6th respondent tomorrow at 10:30 AM with a request to return the certificates and pay the fee due to the 6th respondent receives the said fee. 6th respondent shall return the certificate to the petitioner herein under due acknowledgement. In case of non-payment of the fee, 6th respondent shall return the certificate to the petitioner and liberty is granted to claim the fee. Whereas next page, my lords, it was withdrawn because the transfer certificate, because of this honorable court orders, page number 40, they have withdrawn. Page number 41 is the final order. Page why they have withdrawn because they have transferred the certificate. And for the remaining students, my lords, when we have stated them to approach this honorable court, my lords may see page number 32, what they say for a moment in their proceedings. Page number 25, my lords. Sorry, page number 25, my lords may see their proceedings. My lords have got it. Second paragraph, if I may read, my lords. Second paragraph, fourth line, my lords. The management has kept the parents in dark and played with future of the students. The management has also provoked the parents for filing court cases against the department, which shows disobedience, misconduct, and misbehavior towards the department. This is personal vendetta and vengeance, for this cannot be a ground. They ought to have taken action against the other school for not giving the transfer certificate. When they are requesting the parents, when they have written several letters to the department stating that this is the grievance of the parents and in the interest of the students, they should get the transfer certificates. They focus on me because I told them to ask them to approach this honorable court. Personal vendetta, they send closing orders to me without there being no fault of me. All other 855 students now, my lords, now including this 24, there are only 44 remaining students have to get the transfer certificate. If they take any action against the institution, they will come and they will give the return the transfer certificates. Now the parents are also scared of this DPO managers because he's not allowing them to file the writ petition. He's stating that you have shown disobedience to the department. Can that be a ground, my lords? I'm asking a question to myself. Can that be a ground, my lords? Personal vendetta to stop the students from studying in the middle of the year. Just before Dasara vacations, they closed down the school. Now the same is continuing. They have nowhere to go, my lord. Students will lose an academic year in the interest of let them
Let them give us a last opportunity, we will file and let them take action on the school also, and some time limit may be fixed by this honorable court, by then we will complete.
What is the strength of the students as of now?
Around 900 students are studying in the school as of today. Because of 40 some odd students, my lords. They themselves state they don't come up with the right number once, but the right number is 45 students, my lord, as of today.
45 students.
45 students have not submitted the certificate. I'll show you the. My lords. 46 students, my lords. In the proceedings dated 28/6, they have issued. Page number 21, my lords. That is the number of students, my lords, as of today. Page number 21, my lords.
Paragraph?
My lords, paragraph 1. Paragraph 1 is that the management admitted here about 46 students in class 9 and 10 without obtaining transfer certificate from the students, which is against the rules, and he has treated the parents were misguided. They have informed, my lord, now that they have joined, they may be a difficult state.
Papers passed on by the learned assistant government leader refer to the later dated 21st October 2023, where you have given an undertaking that you will submit the transfer certificates within 20 days.
We are not at fault, my lord. Here we wanted to transfer the certificates within 20 days. Sir, one school, my lords, were colluded with the department. They are not returning the transfer certificate. They are not taking any action against them. That is the collusion, my lords, which I'm thinking of, because and they did not approach this honorable court. They don't have any other remedy. They're not even approaching this honorable court because of the fear, and they're not stating to the department. The other school is not giving them the transfer certificate. Poor students are suffering because of this. Any time frame may be fixed, my lord, by virtue of this order. I will ensure that, my lord, the transfer certificates are submitted, my lord.
What according to you would be the period?
My lord, still December, my lords, maybe 2 months, my lords.
My lord, so it will continue like this.
They have to take action, my lords. They have to let them meanwhile issue proceedings against that school. My lord, for not returning.
The management need to follow the norms of the DO, my lords. They are not at all, they are violating the norms, my lordship.
Apart from this, my lords, we have submitted all the documents which the school required, my lords. I will take my lords to page number 32A also. We have submitted all the documents.
They will take admissions like this in next
They
year.
will not take that was recorded in the without transfer certificate. They will not take any admissions. We are ready to abide by the condition. They will not take any further admissions, my lord, without obtaining transfer certificates. If it was several schools, we would have done, my lord. Only that Siddhartha High School, there is only one school who is doing this. Well within the purview of this honorable court.
On submission, my lordship, first to fifth class also they don't have recognition.
That I will show.
It is like 2020 it was last month.
Thereafter, we have filed, my lords, have produced all the documents. 32A page number also. They have asked us to produce certain other documents which we have done. They are not taking any. They are not responding to the recognition of the class 1 to 5. That is a different issue altogether. Prima facie, the closing orders are passed because PC transfer certificate. The order is also at page number 16. Number 16 is the closing order. That way they do not give reason. They state that the regional joint director of school education, Warangal, by proceeding so and so is hereby informed that the Brilliant Grammar High School as not having recognition for class
All the 46 students are of this school, Siddhartha High School. All the 46 students are
from one school, my lord.
Siddhartha High School.
These are the instructions, my lord, which are given. All are from one particular school. Before there were 60 students, 60 odd students, 24 have filed repetition and they have got back their certificates. And now there are around 46 students. They have to unnecessarily repeat another year, my lord. Half year is completed, my lord. Make a certain time frame and we will comply with the orders.
Yes, friend. I said you have undertaken to ensure. I did.
Pass over matter. Page number 2, item number 11, P. Ravikant, K.R. Koteshwar Rao, Y.B. Ravi Prasad, GP for Revenue.
The submission is that the airport has been shifted and therefore there is no necessity for any issuance of no objection certificate. Yes.
Operations, airports, and other operations of India are not. Police and other authorities of transportation of dignitaries, especially person. Even international agencies are presented. We always. I studied.
Yes, what do you say?
Yes, Your Lordship, but it may be permitted to make a fresh application.
Yes. And find it only.
Page number 3, item number 22 to 24. Passover matter, Mohammed Sharfuddin, G. Praveen Kumar.
Just hold on. Just a minute. Just hold on for a while. Just a minute. Be a copy. Just few matters, yes.
But you don't get that. Page number 4, item number 32, Praveen Kumar Virajala, P. Ramchandran.
Yes. And
Item number 33, Srinivas, G. Praveen Kumar, Deputy Solicitor General of India.
you're filing today? Yes, ready. Have you served the copy to them? Yes.
Item 33, 25873.
Representation. Representation on behalf of the petitioner when the case is called. The counsel for the respondent brings to the notice of the court that the counters have been filed today. List on
Item number 34, M. Abhinay Reddy, D. Nagendra Nayak.
item 34. Yes, if then I'll give another date because I'm in another partner matter.
If 14 to 18 are not there, so any date either before that date or after the date.
And post it on. And post it on 10. Yes, right. Also for the petition. List on 10. Yes.
I request one thing. This model will extend to a week now. Or to the matter of them.
Thinking of granting tax earlier on 27th September 2023. The stand extended till 17.
Item number 35, K. Sunil Kumar. Six, P. Giri Krishna, G. Praveen Kumar.
Yes, right. The township petitioner is present at the request of the
Item.
Yes, list on 14.
Item number 37, R. Gopi Mohan,
Earlier, last again, online, challenging to cancel it. Cancel it, not intended. Respondent number 3 will not on the son of the respondent number 4. Right, because I'm the owner of the property. Just to lead agreement to cover the son of the disabled respondent. He was defaulted. He did not do any work in the property to establish an ILC petrol pump. Meanwhile, Milad, he was expelled. Thereafter also, Milad, nobody is taking it. And I was requested the respondent. I was filed the suit for eviction against the respondent number 4 here. And I was also issued a notice to the respondent number 3, Milad, not to issue any permission. Meanwhile, I was thought the information that the RTA Act, page number 28. There is not a specific question is not that letter of intent was issued on the name of the original LRT is in existence or not. Question number 2.
Yes, I've seen that. Yes, you take out personal notice.
Yes, sir. Nice.
Let us see. You take out personal. Yes, we'll consider. List on 22nd. Yes. Yes. So and so takes notice on behalf of. Take forward a slip to her.
Item number 38, CV Rajiv Reddy.
Who appears for the petitioner? He is not here, right?
Not maintained. With regard to 2 unions, if the petitioner says I am in minority, other majority was called for. It's a dispute between the 2 unions. I don't think it is maintained.
The council is not here. Yes.
Will actually proceed after 3 or 4 percent. Find my count.
Yes. No representation for the petitioner when the case is got. List on 1st December. Yes.
Item number 39, Naveen Kumar B, G. Praveen Kumar, Deputy Solicitor General of India.
Just now I have received the council. Please take the matter online.
Yes, friend. At the request of the council.
Please.
Item number 40, Punam Ashok God, G. Praveen Kumar, Deputy Solicitor General of India.
Malad, the notice of served and I filed the proof of service. Malad, it's a simple matter. Malad, the accreditation committee has given its report. Malad, it was not considered without considering the past orders. My limited request is to the Honorable Court is that Malad, consider the latest report submitted by the concerned authorities to the respondent number 3 and 4.
Proof of service.
What is the date of the latest report according to you?
Yes, Malad, I given the date. 8/9, Malad, 8/9/23. They passed on the 6/8, Malad, 6/9. 2 days prior to the report, Malad, they have reconsidered without looking at the new report. Reassessment.
Is the new report on record?
Yes, Malad, it is on the record.
Page?
Page, Malad, yes. Page number.
You're
Malad, enable report, Malad, 6/9 dated, Malad. Page number 21, Malad, kindly see. Because Malad, I am out of space and the problem. Only my limited prayer is that Malad to recap because they have reconsidered my assessment, the eligibility. The report was submitted by the authority in 8. Prior to that, Malad, they have considered 6. Again, they rejected my prayer, Malad.
There is no report on record. Last page
Malad?
here, there is no report on record.
It is there, Malad. Somebody assessment, Malad, dated, Malad, page 6/9, Malad. Order in appeal 6/9. Yes. It is not there, Milad. It is not filed, Milad. Sorry, objection letter filed and the summary assessment filed.
Not filed. Yes, you file it, we'll consider. Yes.
Item number 41, C. Ramchandra Raju, G. Praveen Kumar, Deputy Solicitor General of India.
Yes, friend.
Item number 42, Punnam Mahesh Babu, G. Praveen Kumar, Deputy Solicitor General of India.
Milad, this is regarding the Milad, without registering a case against me, simply they are basing on some letter written by some third person from Calcutta. My passport was sent for renewal. Milad, the petitioner is a doctor. She has never involved any cases. But Milad, they received a fake letter. Basing on that, Milad, from last 8 months, my passport was stayed, Milad.
Yes.
Without renewing. It was already issued 4 years back. But only I want to go abroad, Milad, they want to full. Some name was mistakenly inserted in the passport, Milad. That is the reason I went for the passport office. Till my tenure is another 6 years also there in the passport. Last question, Milad, I filed another petition wherein your lordship has passed usual orders. But Milad, I without any case, I can't go before any court, Milad.
Here, partial petition, not is getting a and produce the copy to your after. Wherein this passport will get. It's complete. Mechanism not taken by right.
Yes. Yes.
Submit an application along with the first copy of this.
Is the same petitioner?
Yes.
Yes.
Here in the affidavit, action mechanism your it is only submitted to the petition by other petition number 2993 of 2023. This pending. To dispose of the petition without with the condition without that he has to obtain in person. Yeah.
There is no case against me. That is the problem. Otherwise, already the Honorable Court has passed the orders.
Yes,
Who is the other writ petition maintained? You should have filed a review. You should have filed.
That is different, Milad, because what happened? I filed earlier for the correction of name, because I filed the application for the correction of name. At that time, when the matter come before your lordship, then they said there was a criminal case pending. Earlier, they have not issued any letter nor passed any orders. It is different ground. The writ petition filed on different ground, not on the same ground.
Yes. Yes, you file your counter then. Yes, friend.
There are some urgency there, but interim or kanisam. Sorry, plan to go abroad, Milad. That is the problem. there's some early,
Identical prayer. It is identical prayer. Yes.
Item number 43, P. Ram Charan Sharma, A. Ranti Kumar Reddy, VP for Home.
Yes.
And the last ticket to the and I have to make my submissions. All the answers for this today, all I.
Is read. Responsible for the petitioner is present at the request of the counsel for the respondent. List on 9th. Yes. List on 10th. List on 10th. Yes. List on 14th. Yes.
Item number 44, CH Samson Babu, GP for Mines and Geology.
Infractions is read. This representative by the
B. Ramchandra Gaur, G. Praveen Kumar, Deputy Solicitor General of India, K.R. Koteshwar Rao, Y.V. Ravi Prasad.
Yes, right. Request of the counsel for the petitioner. List on 15th.
Page number 5, item number 46, C. Damodar Reddy, GP for School Education, M.B. Rajkumar Gabriel.
I'm appealing for the increased petition. My application, IA 3 of 2016 is pending.
IA number?
IA to include as respondent number 4 in this writ petition.
Have they served the papers? IA number?
IA number is 3 of 2016.
Yes, the cost list was read.
It also reflects in in the cost list.
Registry. Registry to verify and put up IA number 3 of 2016. First, yes. 17th, yes.
Item number 47, P. Achyut Ram Shastri, K. Sanjeev. This case, posted tomorrow, let's for the time.
The request of the council is that
Item number 48 and 49, G. Ravi Mohan, T. Shesh Kumar, A. Agarwal, Rachna Kumar, G. Ravi Mohan. Has been filed. Responded. Order has been.
If item 48 and 49 will take some time, I'll post it next week. Because already 3 matters from council has commenced the argument. And it's in midway, I stopped the learned council. Yes. Item 48 and 49. No, it will come. It's complete the list because midway I had stopped the learned council. 48 and 49. Stood on. And say 16.
Item number 50, GVS Ganesh, G Praveen Kumar, Deputy Solicitor General of India, V Shekhar.
Yes, friend.
51 and 52, Sheikh Prasad, GP for Mines and Geologies, TS Siddharth Sharma.
Yes. There are three matters which have been heard since morning, and the councils are in the midst of their arguments. Then
In this case, I'm only the party to.
Yes.
There are three responding.
We'll proceed. On that date, we'll proceed. Yes.
Okay. Item number 51 and 52, Sheikh Prasad, GP for Mines and Geologies, Siddharth Sharma.
Both are not speaking. Both the without notice in the 2013 petition, the commissioner straight away come to a conclusion and directed their agency as
If I'm right, on last occasion, it was suggested that the matter would be remitted.
Since Milord is
That was the representation. That was the representation.
since he says that the survey was not no notice.
Yes.
The principles of natural justice are to be required.
Yes.
Notice to be. I said, okay, since notice was not given, let the exercise be done. Let notice be given to both the parties. Let the survey be conducted in the presence of the mining department officials, revenue department officials, so that the thing could come to a quietness. That is what I suggested. Yes. But so far as the other aspect is concerned, on the quantum, that is the fiscal matter is concerned, the learned commentator has to submit.
that offer no objection. That's the second petition, 2022.
Yes.
The second petition, the learned commentator has to sustain their claim for a demand against them.
Yes, yes, yes.
Yes, he is not.
This kind of experience that JP is caught up in that.
The first petition is 2013. I think my learned friend has no objection. So ready with that also.
Both of them let the commentator also make a submission to the fiscal matter.
Yes. When can he make his submissions?
There are after 19. After 19.
I said 24th.
Very much.
Same caption, 21st. Yes, it will be disposed. If the government leader is held up in another court, the assistant government leader will proceed with the matter. Yes.
Moreover, in a common.
Yes, we'll do that. 21st. Yes. So the three matters in the morning. Yes.
Passwords matter.
Yes.
Mughal MD Sharfuddin, G Praveen Kumar, Vivek Jain, K Ratnagopal Reddy.
We have completed the first one. We are in the second one, is it not? Yes. No, in the morning, it was the second matter that was going on. Yes. Yes. Let us see that. Yes.
Sino, silence.
Yes, we'll go to the second. Yes, you don't have a copy? Yeah.
I can complete them in time, I will.
5:30.
Regarding NPA. Where the is totally different.
Yes, we were at.
Yes, 5:30.
Yes.
Now, I just come to your lordship and repeat again from the affidavit what he has filed.
Yes.
Now, your lordship will please to see page number para 10 of his affidavit. And this petition was filed, it can be filed in 2023. Moratorium period was minor, and now is taking dates of 2020. In which
This is not working.
Yes.
para 10 your lordship.
Yes, madam.
Now, why I am reading is that the intention of the petition is to get a warrant from this honorable court basing on the circular that has been issued by the RBA on 27/3/2020. Now, para 10 of the affidavit in WP number 532 of 23. I humbly submit that.
Yes.
Very good. I humbly submit the third respondent bank primarily declared my loan account as NPA without any prior regulation or justification. And this is wrong. During the market period, no relief was provided by third respondent rather during such window the account was declared. Market relief is applicable to all the commercial loans which were in default on 1/3/2020, and yet my loan account was declared NPA, and this period of moratorium was taken into consideration for the competition period of 90 days for declaration of NPA. Now, your lordship, according to him, his loan account was declared on 1/3/2020 as NPA. Now, may I request my counter and my documents that have been filed by me, your lordship. My counter and my documents, respond number 3's documents at page number 7 to 11, your lordship.
Yes.
Now, 7 to 11, his petition's account with the notice, a notice has been sent declaring his account as NPA on 26/5/2021. Page 7 of my document. This was the demand notice that has been addressed by the respondent number 3 bank on 26/5/2021 at page number 7 of my document.
They are numbered as R5.
My notice is in my petition, case number 7.
Counter the partition.
Page number 7, your lordship.
Yes.
Notice that was issued on 26/5/21.
Yes.
Now, this was the demand notice that was addressed on 26/5/21. Whereas the petitioner says that his loan account was declared NPA on 1/3/2020, which is not correct. And his account was declared NPA on
9/2/2021, which is at page number 9 of this of the material paper. Now, Your Lordship, this is the notice that has been issued in 9/2/2021. That was not during the moratorium period. Now, what is the challenging by way of this writ petition? Your Lordship, may come to the prayer part. The prayer of the writ petitioner is this. In view of the facts and circumstances, it is therefore prayed that this honorable court may please issue an appropriate writ or order, direction one in the nature of writ of mandamus to direct the referent respondent to initiate instructions and guidance to the third respondent to adapt to the notification dated 27/3/2020, dated circular dated 17/4/20, and circular dated so and so, and subsequently direct the first and second respondent to initiate instructions and guidance for implementation of emergency credit lines. Now, if this particular payer has to be accepted, he is challenging the circular dated 27/3/2020, whether he is eligible for that particular category to challenge this. Now, what is the category under which on this circular is being issued? This particular circular, page number 23 of its document here. It says that wherever the exposure of lending institution to a borrower is 5 crores, if the amount is above 5 crores, then the moratorium period as well as this particular GO will come to this help Your Lordship. But that is not there. Because the amount outstanding as on declaration of NPA was only 1.93 lakhs, so and so amount. Now he has been relying on the Supreme Court judgment. Now you look at Girija Sharma's judgment where my learned friend has filed only a part of the judgment. The rest of the judgment shows there are guidelines that have been framed by the Union of India in this particular judgment, Your Lordship. This was only filed in part. Finally, it was disposed on November 2020. In this judgment, also, the Union Bank of India, central government has framed certain guidelines, which is at page number 17. Page number 17 here. In the page number 17 of the judgment, it says that I state and submit that the submitted in the previous affidavit, the central government took my many policy decisions granting various reliefs for the COVID pandemic, which is a disaster, within the meaning of Disaster Management Act, including the policy decision whereby the following borrowers were declared eligible for the benefit of waiver of interest on MSc loans up to 2 crores, education loans up to 2 crores, housing loans up to 2 crores, consider durable loan of interest. We are not seeking waiver of interest. Again, misleading the plan. I am not misleading. I am just bringing it to the notice of the court. Now, these are the guidelines that have been framed by the government of India by granting some relief during the COVID. Now, GO also says, the GO under which now it is being challenged, also says it should be above 5 crores. Now, Your Lordship may see my counter document where the notice was sent to him. It was 1 crore 90 lakhs. It was 1 crore 94 lakhs 13,382. Therefore, if he has to challenge this GO, it doesn't fall under the purview of this GO. Therefore, the petition is not maintainable. Now, the other point is, having served this notice, this particular notice, Your Lordship, he has received it and replied for it. He has questioned the particular GO in that reply where we have answered it. May I read that, Your Lordship?
Yes.
Page number 12 to 15, Your Lordship. He has replied it. He says that he has not received any notice. Before issuing notice, they have declared me MPA. I have issued notice. He has given a reply on 16/7/21. In this, para number 6, 7, and 8, Your Lordship, he has brought this particular para number 7, page number 14, Your Lordship, of his reply. It says that suppressing the same issuance of subject notice demanding a sum of rupees so along with future interest is illegal arbitrary. Even the Reserve Bank of India in circular issued bearing number so dated 27/3/2020. The same circular he has questioned by way of a reply also. For this, we have also a rejoinder under section 13(3) of Sarfasi Act, which is at page number 16, Your Lordship. Your Lordship, page number 17 of the reply to the rejoinder issued by the bank, that is respond number 3, which is that by page number 17 units. May I permitted to read that unit? That with regard to para 3.7 of the subject matter letter, we submit that the consequent to the worldwide COVID pandemic, India too had faced its unprecedented aftermath, where the sector that was largely affected as a result was the financial sector. In light of it, the financial regulator, that is the RBI, had come to rescue of the banks, financial institution, most importantly, the borrowers via its various release notification. The Reserve Bank of India has issued COVID-19 regulatory package release notification on 27th March 2020, wherein it offered relief measures to the borrowers in form of EMI moratorium on all the term loans for 3 months, that is 1st March 2020 till May 2020. May 31st 2020, which was later extended further by another 3 months through its COVID-19 regulatory package notification dated 23rd May 2020. That is August 2020. To elucidate further, the notification reiterated rescheduling of the payment. Term loans and working capital facilities in view of the extensions of the lockdowns and continued disruption of the accounts of COVID-19, all commercial banks, including the regional rural banks, small finance banks, local area banks, cooperative banks, all India financial institutions, non-banking financial companies, including housing finance companies, lending institutions are permitted to extend the moratorium by another 3 months, that is the 1st June 2020 to 31st August 2020 on payment of all the installment in respect of the term loans, including the agriculture term loans, retail and crop loans. Accordingly, the repayment schedule for such loans and also the residual tenure will be shifted across the board. Interest shall continue to accrue on the outstanding portion of the term loans during the moratorium period. In respect of working capital facilities sanctioned in form of cash credit facilities, lending institutions are permitted to allow the deferment of another 3 months from June 1st to August 2020. On recovery of the interest accrued in respect of all such facilities, lending institutions are permitted at their discretion to convert the accumulated interest for the deferment period from August 2020 into funding interest shall be repayable on not later March 31st, 2020. You have the abiding notification. The bank too had provided relief to you addressed from borrower guarantor to felicitate a smooth functioning amidst the unprecedented pandemic that currently, as well as the banking adapted to the notification dated 5th March 2020 and offered the facility of reconstructing of credit facilities under the resolution framework 2.0 COVID-19 for individuals, small business issued by the RBI. Wherein currently your account is not eligible for the facility as your account does not fit into the parameters framed by the RBI. This was the reply. There was no rejoinder for this after issuing this reply. Now, based on this reply, he went to file a surpassing appeal, Your Lordship. Now, Your Lordship, he has obtained an order for depositing of certain amount. He failed there. This was in 2021. On 23, there was an order. After failing in that before the debt recovery tribunal, he comes and files with the present rate petition 532 of 2023 in the after March 2023. So his conduct, the GO, now what he is challenging, what he is asking, on which GO he wants to rely, is not applicable to him. Therefore, the writ petition is totally barred and the writ petition is liable to be dismissed. Now, one more thing here, before concluding my argument, his prayer in the writ petition was the other prayer, what he seems that he wants to get implemented the emergency credit line guarantee schemes. There is emergency credit line guarantee scheme operation guidelines. These particular guidelines, there are certain conditions that have been laid by the RBI that only these people who will be eligible for getting the emergency credit line guarantee schemes. He himself has filed one of the document there. That particular document shows that. I just want to refer that and I'll close my argument. That is filed at page number 83 to 104 in the writ petition that has been filed under 532 years. 83 to 104. Now, in that, there are certain categorization that has been given. Who will be held responsible, who will be held eligible for seeking all these reliefs under the emergency guidelines. page number 67, Your Lordship. I will just read the first paragraph. Even under this particular scheme, it doesn't fall, Your Lordship. Therefore, challenging that GO under the guidelines of emergency credit grant, he is not eligible to get any relief. Therefore, the writ petition should be dismissed. And his account has been declared even prior to declaring, become NPA even prior to COVID, Your Lordship. That I made mention in my affidavit. Therefore, the writ petition will be dismissed.
Rebuttal only, I will submit few submission, my lord, whatever they have led the misleading submissions. Rebuttal I will submit only. That first they are saying that they turned our account NPA on 9th of February 2021. Stay order of the Honorable Supreme Court was passed on 3rd of September 2020. Now, what here they are misleading, they are saying that Gajen Sharma's order, it has vacated the stay order. I have also placed that Gajen Sharma judgment. That was regarding only to the waiver of interest, not for vacating. My lordship can see that. And the stay order was vacated on 23rd of March 2020. I have placed this judgment, small scale industry. In this, Supreme Court interim relief granted earlier not to declare the accounts of respective borrowers as NPA stands vacated. And one more important thing, whatever RBI is submitting its instructions in Supreme Court, before the Supreme Court, RBI already has submitted writ petition civil number 1 to stand disposed of in terms of the statement made by Shri V. Giri, learned senior advocate appearing on behalf of the RBI, that circular dated 27th March 2020 shall be applicable to all banks, non-banking financial companies, housing finance companies, and other financial institutions compulsorily and mandatory. Already when submissions have been made that have been accepted by the Supreme Court, now what they are trying to do here, just trying to confuse with the waiver scheme, waiver interest scheme and the moratorium circular. Nowhere in our prayer we have said that we are seeking the waiver of interest. Those directions were already issued by the Supreme Court. Now, I think they have not fully understood the writ petition. Interim order came to be vacated on 23rd of March and they committed transfer account NPA on 9th of February 2020. How they can say in the November 2020 that interim order was vacated? Purely misleading the court. Now in para of the 10 of my petition, which they have read, that I am saying that my account was defaulted on 1st of March. I think they have not understood what are the contents. It is written moratorium relief applicable to all those commercial loans which were in default on 1st of March. That means the status of the accounts on 29th of February 2020, what was it? It should be maintained. No further NPA classification was as per the circular dated 27th of March. Here I have said that my account was under default. I am saying moratorium is applicable of all those commercial loans. So I am just interpreting the circular. And when they are turning the account NPA itself is illegal and void, contrary to the apex court stay order, then their all further submissions they do not survive. Now they have brought to the surfacing proceedings. We are not seeking any relief under surfacing proceedings. Whatever they want to do before the DRT, they are permitted. Our prayer is only confined to the implement of circulars and emergency credit guarantee. And also one important thing is there in these matters, that in our independent India, for the first time we are facing such kind of issues. This pandemic occurred, after that such kind of mitigation scheme. And the turning of accounts NPA was not in the normal course of nature. It was due to a disaster which was not under the control of humans. In those circumstances, they were bound to follow the circulars, stay orders and guidelines which were issued for the benefit of the public, general public. They were duty bound. By ignoring them and proceeding in a casual manner, that cannot be permitted. and it is the violation of Article 20. So when the account itself in February it is shown, it is proved that it was contrary to the stay order, then how they can say Ajay Sharma's order was regarding the waiver of interest. Now, in the counter affidavit, my lordship will see.
Yes.
In the counter affidavit, they have proved that why that circular was not applicable, for what reasons we didn't provide it. So counter is related only to the DRT proceedings, and we are not at all on the DRT proceedings. My lordship, in 1183 petition, which is the first petition, this difference is only that during the moratorium period, no account should be turned NPA. What was the status of 29 February? That should have been living till August 2020. After August 2020, stay order of the Supreme Court came, which survived till March 2021. In that period also, no.
1 second. Learned counsel appearing on behalf of RBI. What do you have to say on that?
Yes, so as the submission with regards to this respective balance and as to the applicability of the circular to the banks, but the discretion as to how this particular circular has to be applied by the banks is, I have submitted my there will be more about the policies of each bank because each customer profiles of varied banks, thousands of customers, only the banks will have. Since it is left to the discretion of the banks, you make a board policy as to how to implement the circular. But any board policy should be in tune with the circular. Once you make a policy as to who would be eligible, who would not be eligible, in tune with the RBI circular, then the discretion is left to the bank in its comfort.
From what I am understanding in all the writ petition, the limited grievance of the petitioner is that the circular dated 27th March 2020 is not being followed. Admittedly, we cannot direct the RBI because even as per the governments in all the three writ petitions, he has not represented to the RBI as on date. So we'll dispose it of directing him to make a representation to the RBI.
RBI may be directed to consider it and respondent number 3.
Consider it in accordance to law and pass appropriate. We cannot direct the third respondent because writ doesn't lie against the
this issue has was also dealt.
No, as far as the federal case, as per the judgment forwarded by you, we cannot direct the private bank. So we will only direct the petitioner.
Public decree, it is under the MBED. Can you see the apex court judgment was related to service case.
Yes.
Not for the implementation of COVID-19 circulars. These circulars were issued for the public benefit.
Let us not. I'm only trying to see. Let us not complicate the issues. Yes. Yes.
Arguments have already been completed. Now, again and again, 4 times, 5 times.
See,
now election will pass order.
I will not give any direction to the third respondent.
That's true.
The direction would be you would give the petitioner, without going into the merits of the case, the petitioner is directed to submit a representation within 1 week or 2 weeks, whatever, a detailed representation explaining his grievance with regard to the non-implementation of the circular dated 27th March 2020 to the RBI, and RBI to take action in accordance to law within a period of 2 weeks thereafter. Beyond that, nothing. I'm not referring to any of the.
Yes. Like once the banks make decision as to it is not eligible for classifying for this RBI circular, they are not eligible as per the board approved policy. Once the communication is received from the bank to the petitioner that we have approached the bank for the moratorium, the banks have informed us that we are not eligible for the moratorium as per the circular. Once the decision is put before us, the RBI, then RBI can take a call as to whether that decision of the bank is in accordance with the RBI circular. That limited thing we can say, but we cannot step into the shoes of the bank to say that
But just now what has been passed on to you? That answer that.
Respondent number.
That answer, you can just pass it on to the learned senior counsel.
Respondent number 3 is also attached with that form. Also, when RBI falls under the ambit of Article 12, then respondent number 3 can also be directed to.
But respondent number 3 again, Federal Bank judge.
I also received oral instructions today morning itself, my lord, that insofar as direction is concerned to RBI take action in accordance with the laws of condition. The RBI only requested 8 weeks time because various stakeholders are involved.
Yes, we'll do that. Yes.
That's the last.
That's.
Then my lord, and there we are challenging that the first action itself is illegal.
No, my lord.
No man, without even addressing a representation, there cannot be any mandamus. That is settled law. You have not even represented. How can you complain in action? Yes. We leave it at that. We leave it at that. Yes. Yes.
This question is concerned. First of all, it doesn't require any court order to say that the RBI circulars do not bind the parties. The RBI circulars would bind the government and the not the government, the banks working under them who has taken license from the RBI.
Yes.
And as per the finance minister's directions. This is a statement made across the bench by the other people will be observed. But that doesn't require a reiteration for today. The issue before this court is whether he is entitled to.
Yes, let us see the Supreme Court order.
No, you want to see circular first. This judgment is not whether circular can affect him or not.
This state will never be able to resolve.
No, that's what the law. That even the law. There can't be a direction even to consider he must have focused on.
There is my lord. Action has been proved illegal.
Let us see that. The apex court judgment which you passed on in the morning. No. Pertaining to the circular.
Small scale is this one.
Not this one. Page. Page.
No, not in the petition. In the small scale also I have that particular field.
So one page order. One order.
Number 16. Petition 1183.
Page 69.
Page 69. Red petition number 1183.
It has against respondent number 3 dismissed them.
Respondent number 3 is also covered under this. So they shall be connected for the damage.
I'm not saying anything against respondent.
I'm a party for something has to be said against me.
I'm only giving a direction to the second.
That's true. Then disposal of this representation because it is the first stage and we are saying that now again and again disposal because we are saying their first action is itself illegal. So all subsequent actions till then shall not be allowed to. Precipitative action shall be taken till the disposal of it is not. There is not the action. It is the natural justice. When their first action itself is that's what I know. This is the way then how they can take further action? Then their all proceedings will go. So till then we are seeking protection after that. We are free.
Now they will go to DRT and say, therefore, those things.
No, that is our intention for the
They have violated the order that has been passed by the DRT lordship. They have not paid the amount. They have been directed. Now they say that has been filed got dismissed. After dismissal, now they are pressing from this particular repetition.
It has been filed in January.
Now, your lordship is pleased to say in my repetition, page number 18, I have clearly stated that
they are not agitating
what you are seeking under the the circular dated 27th March 2020. I've already stated that that has not been put to challenge.
We are not asking for waiver of interest.
Against this, he has not challenged. After 2 years, he has approached DRT. If he has not approached DRT, if he has come up directly before this wonderful court, that the matter, the things would have been different. He has approached DRT, failing that he did not pay the amount what DRT has directed. Thereafter, he comes to
complied, my lord, and High Court granted the stay. Now again they are misleading on every point. No record, nothing to show. Direction shall also be to my lord respondent number 3.
In my case, the public shit, your lordship. This is my.
Can you see that the judgment of the Karnataka High Court, same issue has been there. Same issue. As he has
come up with some other petitions and documents.
So they should have followed the circulars during that time.
Yes, now we'll conclude.
I have taken
We'll conclude.
so precipitate.
I think that's the key. Not just on the second, it is.
No, some direction shall be there.
I should respond to I have no issue. But as against the it has to go. So that when he had represents are gone. Otherwise they take it. As it is, he wants to stay from here. Anyway, that's the
stay. We are seeking that they have to take first step is legal, then what is here is the question of rest of the proceedings.
So no.
Then no chance that precipitative action.
What the court has expressed now, the court has not come to a conclusion saying that the first step is illegal.
So that's why I am asking decide for them, for me. Let the decide that between issues. Nothing is they have been found violated. But they given to be taken
Now that we are applying private banks, your lordship, so much of amount, your lordship, please to see how much.
So much of amount.
They are begging us to run around the courts, obtaining stay, and we are answering.
If they would have followed all these things, everything would have gone in a smooth manner. But they deliberately compelled the parties to run their
they have become just for the shrine of the banks. It's not one bank. It is a Crescent Bank here, it is Axis Bank here, and some other banks. And the amounts that are being involved is around.
These are arguments on the here. Directions may be there, so that first of all, what it is being there.
No, I take serious objection to
what serious objection, which is the other bench shows? Which is the other bench? Which is the other bench?
If you continue like this, I think I'll not even proceed with the matter. I'll not even proceed with the 3 matters.
He wants to visit the series discussed there. He asked me to be present there, but finally a restoration petition.
Court has issued notice. They also they are
applying. Say that court has to come and appear.
They are hiding it, just concealing from the court.
Instead of 8 weeks, can't it be done in 4 weeks?
The various stakeholders are involved as to what are the decision of the bank is and where there is going to multiple communications, because apart from the regulatory work of the bank, RBI, this would be in addition to it. That's why 8 to 10 weeks is what I've been instructed to request the officers.
The thing which is passing in my mind, I just share with you. Your lordships are now directing RBI to consider whether the moratoriums are extended to this unit.
The decision taken by the banks.
Now, alternatively, if what is sound courts directing them to what the RBI will do now, question that I put to myself. RBI cannot do anything at this stage. No, they have no role to play. They are like it's like a statute. Every state is statutory body. They have to extend. Implementation part is someone else. Today they can't say they can't say today also one second. Today they can't say please execute by surplus. That will be beyond their power. If somebody has violated the surplus, the law will have to take its own course. It's like somebody violating statute. These surplus are in the nature of legislation. Guidelines to the banks, which the banks are required to follow. If there is a violation, they can't say that the next account will follow this. Or you don't impose any, you don't take steps to recover. That would be banking. The system will collapse. Tomorrow the banks start monitoring these accounts.
Concerns of the.
One second, please, let me complete. If I have violated any law, the law will have to take its course. If I have not violated any law, if I have followed circulars, the law will take its own course. RBI has no, so many individual accounts are concerned. But today they cannot decide whether it is NPA or not. It is for me to classify. If the classification is not in accordance with the rules, either the courts or the DRT or the civil court, wherever it approaches, will find fault with me, set aside that action. But RBI cannot today say, please don't classify this as NPA. They cannot even decide that. They cannot take any judicial action so far as this particular account is concerned.
They can take.
That is the question which requires.
I may clarify. When RBI generated
It's here to the council, yes. Yes.
I was more than like for the reason that RBI, since it's a regulatory authority, cannot step in the shoes of a banking act. If at all any action of the bank is in violation of the law, then they have the remedies under the statute to approach this honorable court or the leaders to set it aside. Unless the petitioners make out a case of violation of any statutory duty cast on by a banking regulation act, they cannot seek a positive direction. I being a regulatory authority, I can state if at all the bank's approach is more by way of representation. By looking at the record, at most maybe I can say that this is in tune with the RBI circular, this is not in tune with the RBI circular, but me giving a positive direction to the bank, the amount of banking activity, if I may say this. Then they may, the next course of action, which may they have this, basing on my decision, they may have to rush back to the court stating that since RBI themselves has stated that it is in violation of the RBI circular, set aside the classification of NPA account and declare it as a standard account. They may have to rush back to the court again.
That's why, first of all, let them find out, and that's what court is directing, that we will simply stand that whatever grievance is, and they will decide. And as they are saying, they are the regulatory authority, so banks are not free from them. They issued the circular, and it was duty for the banks to implement those circular, and when directions of the tax court were there to implement by them, then they cannot say that how we learn. That is the point.
We have never failed in not to be allowed.
And every year they are submitted.
Petitioner in this case has never approached us.
Because that's why we are saying.
It's a regulator.
No, when he has come, your lordship, let it show his bona fides.
My lordship now pass the orders.
After 34, it did not come to the court. After taking possession,
their previous doesn't show that they are wrong on their
the DRT. There he got some stay. Thereafter he come here.
Their doesn't show they are wrong on their part.
Also, there are no true disclosure in the petition about the DRT proceedings, not getting been unsuccessful or that everything has been silent.
DRT, you are not challenging.
Even on the equitable.
You are not challenging, but it is a challenge.
At least there have been no what has happened about
Suppression.
In the suppression of material facts, the lordship is pleased to say 27(3) circular clearly indicates who are the persons who are eligible under section under that particular circle. It is above 5 crores people are only eligible.
Again, they are misleading.
Because had they been successful in DRT, this wouldn't have happened. Because they were successful, this has.
These are the qualitative submissions. What is the legal submission?
Yes. Yes, you want to say something?
The only thing we want to say is purchase plan also go to the but 8, 9, 10 of them.
Yes.
Similarly, the other respondent banks. Then the worship still is their case is considered. The representation, proposed representation is to be made by them. But still, I say RBI has no role to play.
Now he is defending RBI sometimes for his respondent number 3. In all, they want that what action they have done that shall remain suppressed. That cannot be done.
written instructions on record. The RBI written instructions was submitted that the commercial relationship between the bank and the lender, and so far as the circulars are concerned, it is a matter of discretion as per the approved board policy of each bank. If at all they are eligible, they are eligible. Otherwise, they are not.
Board policy was for restructuring my loan.
Yes, where is the copy? We have given it to written. Written. Yes, we pass on to the council this.
Instruction, they have already submitted to that.
Instructions for the cracks of the usually circulars, and there are board approved policies which the bank has to formulate.
Issue between the lender and the borrower.
Issue between the lender and the borrower, because each customer profile is with the bank. We do not have access to it unless circumstances.
That's why my not responding. Which are also be directed.
But the stage will not, since the board policies of the each bank governs as per the circular, they're eligible, they're not.
They were found on duty under the export order. Respondent number 3 is the implementator. That's what I was going to say.
We have to state in the touchstone of the surplus. If we have violated the surplus, punitive action will follow against us.
So that for only we have given them representation.
Please, sir. See, there has to be. So suppose that my bank has violated the surplus. It's like violating the statute. Now, once I violate the statute, I will not be relegated back to the statute. I will have to find out whether I have violated or not. If I have violated those surplus, the action lies for some other forum, either the court or the DRT. They have knocked the doors of this court initially by finding a restriction in my case. Whether they were relegated to the DRT. The DRT is now seized of the matter, it passed an interim order, some amount was directed to Boston. That is the interim order of the court. The restriction of initially was entertained. Then they were relegated back and they were filing. So that interim order is being continued. That's how it is. Then subsequently, the estate got dismissed for default. Now again, they filed restoration. That is probably not
before DRT possession notice was checked.
Even
where these circulars have been placed before DRT. Now they are shifting from both these places. The DRT is pending, it has been disposed of.
1 second, please.
So when they are checking for 10 times, he is continuing. There's the decorum of the court. He has already submitted his submissions. I have submitted my rebuttal again and again, keeping the argument. My lordship will reserve it for the order. He will not listen.
I cannot control what I have to say.
They will keep arguing until the orders come. Because they are on the fault at their first stage. That has been caught. That is my only submission.
Yes.
RBI is a regulatory authority. If they will found on the record, they will be penalized and damages can also be recovered from them. Due to their conduct, our entire entity has been closed.
They have read out the grounds in the clear TSA. One of the grounds is this. The circulars have not been followed. Surplus Act. All these tokens are available, all these pleadings are available to them. Like saying that it should not have been classified as NPA. Now, if it is not, it can't be classified as NPA, there are two reasons. The reason is that this circular was not followed by us. That's what's been taken care of by the DRT when the matter is pending. That's what, because that DRT can go into factual aspects. Now, once we say the circular has no application to the instant loan account. That's a matter of this court probably the rate petition. No particular on SC is pending, not going. And that factual aspect, now I put a question, another aspect, another situation is realized. But I am not first saying on behalf of respondent 3. So this has got a larger repercussion. Such orders would have larger repercussions. Tomorrow, every borrower will say that X bank is not following RBI guidelines. Submit a representation to the bank. It does to RBI. on examining all these accounts, which is not the job of the RBI. If some bank is not complying with the surplus of RBI license will be cancelled. That is the maximum they can do. They can't even enter into the head of a private bank with its borrower. It's a matter between me and my borrower. Suppose I overcharge my interest, like a gambling one. Tomorrow the bank will say, well, RBI is simply saying the license is cancelled because you have violated NBFC conditions. You have violated banking conditions. That's all they can do. They cannot write off this loan. The loan will have to be written off by me and by them. If RBI start doing it, economy will go somewhere else. Because that is why I'm saying this more as a responsible court officer.
Yes. Second, this period, because that whatever we learned in the banking act, at the end of the day, either the petitioners have to make out a case with regard to violation of the circle before this honorable court has the rectification, or eventually, if at all he wants to make a representation, and if at all RBI says hypothetically that RBI circle is the decision of the bank is according to it, we cannot direct the bank write off this NPA and restart the session. We'll say it is in violation, and then we have punitive measures as to for the violation, which are not visible. And again, he has to go back to them. Okay, RBI also is different in our case. The prayer to set aside the classification as NPA, because we cannot take a decision as a regulator to say declare this. If it comes to banking commercial activity, which is RBI is not immediately even as per the spirit of the banking regulation. Because we are at the end of the day, when we put this, we are at the end of the day, we are backs in a whole situation. We may say, so what is wrong, what is right. There ends the rule, and we do it on a quarterly, yearly, or whatever the streamline is as banking regulation.
First of all, DRT has no jurisdiction to decide the fundamental rights. They are again and again asking for DRT. Here we are for some other thing. Secondly, RBI, when already directions of apex court are there, then they cannot shift their burden to the banks, because bank never issued those circulars. They are the generators of the circulars for COVID-19 relief. So they cannot now keep their hands aloof that no, we will not touch. They have to, and still yet it has not been clarified that circular was implementable. So for that only we are sending representation. Whatever their contentions will be, whatever their decision will be, they will apply to us. Further legal remedies are always open to the petitioner. We will seek them. But at this stage, they cannot say that we will not do this, we will not do that. Respondent number 3 is under the bound and duty. And whatever you analyze, we are not worried about this account. We are only worried that tomorrow there will be possibilities and nothing can be done. So everybody has power. They'll stop coming to us. No, if they have committed wrong, it's what if they say, sir. Next is violating his bank to a circular. So RBI should they have violated 60,000 suicidal cases due to the conduct of the banks. 60,000 suicidal cases during the COVID-19 has to be met. As far as my case is, therefore, we have clearly stated RBI guidance will not be applicable. My lord,
the loan is less than 5.
Yes, I agree.
You said that the loan is less than.
Not only that, there was a reply that was given to the petitioner when he has issued a reply to 13 notice. There I have said that in that notice he has challenged this 2023 circular saying that I come under this, he have violated all those things. Then I have replied it, I have mentioned it clearly that you do not come under so and so. That particular circular has not been violated, that will not come under so and so. Thereafter we approach here. We did not challenge this.
Yeah, that's my case, my lord. 30 seconds.
No, 1 second before. I just finally I'll read this particular part where in 532 and 16
not the arguments may be ended.
Yes.
Like it will be endless.
Yes.
Yeah. But currently under the
page
my document at the rejoinder here. Page number 53.
Yes.
He did not file that reply. He actually did not file. He filed a notice that has been issued by him. But he did not file his reply and my reply, rejoinder to that reply. In this paragraph, page 18, your lordship will please to see. I have clearly rejected that. The currently banking notification dated reconstructing of credit facilities under the resolution framework COVID-19, the individual small business issued by the RBI wherein currently your account is not eligible for the facility as your account does not fit into the parameters framed by the RBI. This has not been challenged. We should have challenged this. How he doesn't fit into the frame, fit into the parameters formed by the RBI. I have issued this. I have clearly stated that it doesn't fall under the RBI. That the circular dated 27/3/20 will not come to your rescue. We have followed all the guidelines issued by the RBI. And this has not been filed before this honorable court. This is again a suppression of material fact.
Thing has been suppression, my lord. The circular of which they are talking, nowhere it is written that up to 5 crore loans against they are confusing. In Gajen Sharma's judgment, that was a waiver of interest, that during moratorium period, you shall not charge penal interest. So the RBI framed that loans up to 5 crores are eligible for not charging penal interest, not for circular. My lordship can see that judgment. I have also presented Gajen Sharma's judgment. It is there in the yellow pages. Circular was applicable to all. Page number 21, everything has been clearly written. In respect of all term loans, there is no any boundary line that 5 crore, 2 crores. Even 50 crores, everything was applicable. So again, they are misleading. Gajen Sharma's judgment is on the waiver of interest. We are seeking for the moratorium circular. And main point is that when circular was issued, there shall be no classification of NPA. This has to be seen by the RBI that whether your circular was implemented properly, because now banks are under the fault, and if bank will be found in under any fault, then RBI is the regulatory authority. It has got powers to take any action. Now they cannot say that every borrower will come if they have committed wrong. They have played with the fundamental rights during that crucial period. Then they cannot seek this defense.
No, you are pleased to say when you have automatic rates, commercial transaction. What commercial transaction? COVID-19 commercial transaction, right? Waiver of people are dying. Appreciate government said if it was in 2020 COVID period or 2021 COVID period. So why didn't you follow that? 23 after 2 years.
Why didn't you follow? There was a diversion by the Supreme Court. Content petition was pending in writ petition 16637. Then it was disposed of. Then Supreme Court directed to approach to the High Court. After that, we filed this petition against the HIGHCOURT. And when they had done already in 2020, they should have followed. It was their duty, not ours.
Yes.
Item 29. Mentioned at 4:30.
Yes, yes.
We have informed the other side.
20th. Item number? What was that?
Item number 29, 31.
29 to 31.
Yes. Yes.
20th.
Right?
Yes. Yes.
The judgment is up.
I'm representing extension for interim orders, Your Lordship. Your Lordships have directed to post the matter. A request for 9th, Your Lordships.
9th?
WP number 47650 of 2023. Extension is today, Your Lordships. It's expiring today, Your Lordships.
Want it on 9th?
Yes, Your Lordships.
Yes.
CVL.